I am muted. Sorry, I forgot to turn off to unmute my audio. Mm. Good morning. Good morning. Thank you, chat. You see, it's too early for me in the morning. I always have these boomer moments. I always forget to unmute my audio. So what's going on, guys? How's everybody doing this morning? You're muted. Yeah, I see I'm muted. Thank you. Good morning, everybody. Good now. Thank you. So we're at the end of an hour with this trial, right? It's virtually over. I don't know what the McMichaels are going to do, but if the jury instructions are what they are, we're probably looking at convictions. Some people have been taking bets whether the jury's out for 2 hours or more. So we will see. Somebody said the judge is back. PBS hasn't started. Let me look to see if there's another feed that I can look at, because PBS is not there. Here's 11. Let me switch to that. They have a live feed in the court. What happened to the toothbrush? Oh, because I'm not using any sugar, so that's what happened to the toothbrush. Let me stop screen sharing this and let me go to the News 11 feed. Their audio sucks though, but I'll try them until PBS gets their trial in Ahmaud Arbery. I'll use PBS until they get their self together, because PBS is starting to stream. Boop. So here we at. I love the eagle on top of the American flag. All right. Well, got some super chats coming in already. All right, and thanks again for the super chats, guys. You don't know how much these things really help, because these streams are like demonetized immediately. So, and I love what they do. Right, they'll demonetize them all day while I'm here, even though I'm not cursing, not talking about anything horrible. They'll kill it, and then right after, when I get like all the views are in, then they remonetize. It's like, all right, well, it doesn't work. I predict at least 2 hours, 2 more. I predict at least 2 more motions for mistrial from Roddy's attorney. Yeah. He's like the king of mistrials. He's going to be coming. Mistrial. A verdict is it? Not yet. The jury hasn't even gotten it yet. But I don't know if you guys saw the what you called the trailer that I put, but all the attorneys here online, all the YouTube attorneys, have more or less believed that this is going to be a guilty verdict pretty quickly. So that's just wrong, YouTube. It's weird because the judge said we're starting at 8:30 tomorrow morning. We want to get it early. It's 8:30. It's here. Judge, he's back. Verdict in. Toenails dirty. Oh my God, he's with the toenails. All right, let me stop just gillygagging around. So what has been going on? Why are we pretty confident that this is going to be a guilty verdict? All right. So first, there's no guarantees, right? This jury can come back and say these men are not guilty on all counts. Possible. I'm not saying it's not. Whenever I do these predictions, I like to give percentages. And generally my percentages go from 60-40 to 70-30. This one I'm giving 80-20. And it's because the defense has essentially conceded that the citizen's arrest was illegal. And that concession is going to kill is going to essentially direct the jury to vote guilty. That concession is going to make the jury vote guilty. Darkin says it's got 95.5. Some people are saying 100%. And if they violated the law, if the citizen's arrest is not guilty, it is illegal, it's over. So Travis guilty of all but malice murder, Greg guilty of all but malice murder, Roddy guilty, ergo, assault, felony imprisonment, likely guilty of all but malice murder. Yeah, I agree. I think the malice murder is an overcharge.
Defendants are present.
Here we go.
Understand the state is to proceed.
Yes, Judge.
Anything preliminary from the state?
No, Your Honor.
From Travis McMichael.
No, Your Honor.
From Greg McMichael. From Mr. Bryan.
No, Your Honor.
All right. The jury is here, ready to go. Let's go ahead and get the panel.
So now the one thing I will say about this, and I do have to say this, listen to this. The big issue that we have here is that yesterday, the prosecution, the defense went so long that the prosecution was not allowed to rebut yesterday. So you let the jury go home and sleep. You let the prosecutor go home and take detailed notes about everything they heard yesterday. Everybody's fresh, attentive this morning, and the prosecutor is going to give the jury her rebuttal for 2 hours with a fresh, wide-eyed, coffee in their belly jury. This is a disaster if you're the defense attorney. That's why tactically they should have ended at 4 o'clock to make her give that 2-hour closing at the end of the night, right when they're tired. So this is not going well for the defense. Just this. So now let's see if she can close. If this prosecutor can close the door, it's going to be over. So she's been good. She's been good, but we're going to see if she can close this door this morning. And just for everybody to already understand, the defendants have already conceded that their citizen's arrest was illegal as a matter of law. That's concessions already out there. They haven't told the jury that, right? They're not telling the jury that, but as a matter of law, they've already conceded that they weren't conducting a lawful citizen's arrest. So, what do we, this is what we're watching. Let me see if this other stream is getting some better audio.
Good morning. Appreciate everybody being ready to go a little bit earlier today. Welcome back. We are ready to go ahead and proceed with the closing arguments in the case from the state. Ms. Duncaster.
Thank you, Judge. All right, good morning, everybody. Good morning. All right, so yes, the state has another 2 hours to speak to you. Now, some of you may be thinking, please, no, I understand this, I get it, I've got it. But the defense got up here and gave you a lot of information, and the person sitting next to you.
I'm going to switch streams because this one is way too low. I don't know what they're having a problem with their stream because their audio is always so bad. I'm just switching streams to PBS because that audio is just monstrously too low. Here we go. All right.
Please, no, I understand this, I get it, I've got it. But the defense got up here and gave you a lot of information, and the person sitting next to you might have questions that you don't know. So when you get back there in the deliberation room, I want to make sure that I've covered everything so that we're all on the same page as far as the facts and the law.
Correct.
So what we're going to do right now is we're going to get back to the basics. Okay, we're going to take it back down. We're going to apply the law to the facts, and that's what we're going to do. We're going to walk through this right now. So the burden is on the state to prove.
Thank you. I'm going to try and look into that.
Beyond a reasonable doubt. Now, Ms. Hood, Laura Hogue got up here yesterday and said, you have to be certain. That's not true. What it is it's the doubt of a fair-minded and impartial juror honestly seeking the truth. Not seeking doubt, not beyond all doubt.
Thank you,
or
Navy.
to a mathematical certainty. And that's what the judge is going to charge you. Okay? All right? It's just beyond a reasonable doubt.
On civil
In
law.
other words, do you think they committed the crimes? Okay, if you go, yeah, I think they committed the crimes, you're good. That's all you need. Now, the defendants have raised what we call affirmative.
I'm going to object to that description of what reasonable doubt is. It's clearly not.
Yeah, no, that's definitely not what reasonable doubt is.
Objection.
Okay.
Court's going to charge the jury on the definition of reasonable
You think they
doubt.
committed the crime or good? That's not quite what reasonable doubt is. No.
Have everybody argue.
Slip it in. Slip it in.
No, I mean, the defense was going the hard way, the other way. Yesterday, it was
Yeah.
like beyond all doubt and all the rest of it. So you might as well, I guess, counter the complete opposite of
Doubt
that.
of a
Jesus Lord.
fair-minded and impartial juror honestly seeking the truth. Not seeking doubt, not beyond doubt, or to a mathematical certainty. That's what the judge is going to charge you. Okay? Once again, if you believe they have committed these crimes and the state has proven it to you beyond a reasonable doubt, you are authorized under the law to come back with a guilty verdict on all the charges. It's as simple as that. Now, in this case, The defendants have raised an affirmative defense. And what does that mean? An affirmative defense means, hey, even if you think we really did these things, because the evidence is sufficient to say, yes, we did do these things, the 4 felonies in the indictment and the murder, hey, we have an affirmative defense which justifies us doing that. For the murder, it's self-defense. For the other charges, it's citizen's arrest. So here's the thing. You find they didn't commit a citizen's arrest. That's not what they were doing. Under the law, they didn't meet the criteria. Okay, I want to remind you guys, ignorance of the law is no excuse. It's not like, well, they were probably mistaken. You can't be mistaken about the law. If you're going to take the law into your own hands, you better know what the law is. So if you find they were not doing a citizen's arrest under the legal standard, okay, the judge is going to give you, well, then it takes it out of self-defense for the homicide. And that means they're guilty on all the charges. All right? It's as simple as that. So count 1, malice murder. Remember, premeditation is not required, and the state is not required to prove motive. All right? You may find malice when there does not appear to be significant provocation and all the circumstances show an abandoned and malignant heart. Okay, I want to be real clear. The state is not saying that Greg and Travis McMichael ran out of the house to go murder somebody right then and there. We all know that's not how it works, right? Okay, what happens? Let's give you an example. I'll make up an example. She's leaving him, right? They're getting a divorce, and she's there to pack up her stuff. Okay, he's not at the house to murder her, right? No. But what happens? She's packing up the stuff. They start arguing. They start bickering. Then it starts into shoving. Then it's, if I can't have you, nobody can have you. She's thinking, oh my God, he's an idiot. She's taking the stuff out to the car. He goes up and kills her, shoots her with the gun. Okay. It started out one thing, and it escalated and escalated and escalated. That's how you get to the murder. So don't be fooled, okay? The state's not saying they left the house to go murder Ahmaud Arbery. What happened? They left the house to go investigate, right? Stop, we want to talk to you. Where are you coming from? What did you do? What's going on, right? And then what happened? Mr. Arbery ignored them, okay? He took off running. He wouldn't do what they were commanding him to do. He wasn't obeying their orders. Why? Well, under the Constitution of the United States, he didn't have to do anything except walk away. In this case, he ran away. And they chased him. They backed up on him, and then they followed him down Burford. You saw the Night Owl video repeatedly yesterday when Mr. Goff was here. At that point, I mean, let's face it, to Travis and Greg McMichael, that was a big go jump in the lake. I'll use polite language. I mean, wasn't it? Here they are, ex-law enforcement, Coast Guard. We're demanding that you stop and talk to us. We have questions. Stop right there, talk to us. And he ignores them, basically telling them, yeah, I'm not doing it. And it starts escalating. They start getting mad. Oh yeah? And then all of a sudden, Brian pulls out. Then it's like, okay, we'll go around and we'll cut him off over here. We'll go get him. Now they want to get him. Now they want to stop him because they're mad at him. He has totally ignored them and run away from them. And how dare he do that to these two people? Okay, what right did they have to stop Ahmaud Arbery? What right did they have to go ahead and demand a fellow citizen stop and talk to them? And then use pickup trucks to try and cut him off and force him to be detained right there on Burford? None whatsoever. So when we're talking about malice murder, we are talking about the fact that this can happen. And the judge is going to charge you on this. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. How do you see malice? Well, you can consider it as reckless disregard for human life. You bring your 12-gauge pump shotgun with you, ready to fire. You point it at a man you know is unarmed. I mean, you think they couldn't tell with those baggy shorts that he didn't have a gun on him? Who's being forced toward you by Mr. Bryan and his black Silverado, and then you go ahead and intercept him and pull the trigger without a thought. Abandoned and malignant heart, reckless disregard for human life.
Just giving myself a mic check to check the audio levels, guys.
And they're in it together. Greg McMichael and Travis McMichael are acting together in concert in the truck. Their actions are all together. They're parties to the crime. Even though Greg McMichael is in the back of that pickup truck on that 911 call, when Travis pulls this trigger, he is still responsible because he's a party to this crime. Because without Greg McMichael, this would never have happened.
Yeah, the issue is she's not
Now,
talking
felony
into the
murder, once
microphone,
again, is based on the
so
four felonies.
this is the best thing. That's why we're
Now, the felony murder
overtaking us.
is you're committing a felony. There's no intent to go ahead and kill the person, but because you're committing that felony, someone dies. Okay, let's not be fooled. We're not talking about but for his parents getting married. That's the red herring. What are we talking about, ladies and gentlemen? But for the felony. Okay, that's the thinking. But for the criminal attempt at false imprisonment. But for the false imprisonment. But
what she's
for
doing is
the
going
aggravated
over the other
assault
stuff,
with the
and
motor
she's going to
vehicles.
end
But for
with
aggravated
the
assault
arrest,
with
the non-citizens
shotgun.
arrest, because that's what you want
You
them to
and
go
me,
into.
That's
So
how you
all
think
this
about
is
it.
just
Look
preview,
at
but
these
as soon as
crimes
we
and
get to
ask
the end,
yourself, okay, if we
she's
take
going
that
to
out,
we're ending on the
would he be
citizens
alive?
arrest being illegal,
It's real
and that's what she's
simple.
going to have the
The
jury
answer
go.
is you can't take
anyway,
out
so
any of these crimes.
That's what I
You
would
take
do,
out any
and I'm
one of these
assuming this is a
crimes
competent
that they
jury,
committed,
so.
and he's still alive. All of the underlying felonies played a substantial and necessary part in causing the death of Ahmaud Arbery. What do we have? Aggravated assault with a shotgun. Pretty simple. The aggravated assault was continuous. Started with pulling that shotgun up. Ahmaud Arbery was 30 to 40 yards away, not an imminent threat at all. And what did it do? It ended with the pulling of the trigger, shotgun
That's a good
blast
point.
here, pellets right here. Did that felony contribute? Of course it did. It's the cause of his death. Aggravated assault with pickup trucks. I want to be real clear about this. You do not have to hit the person with the pickup truck. The judge is going to charge you that actual injury to the alleged victim need not be shown. What has to be shown? This. Were the defendant's actions such that it placed Ahmaud Arbery in reasonable fear of immediately receiving a violent injury? What did Mr. Bryan do? He actually ran him into a ditch. Check. I mean, Mr. Bryan right now, aggravated assault with his motor vehicle, check. Felony murder, check. Because this contributed to his death. This played a substantial part because it put Mr. Arbery in reasonable fear of Mr. Bryan and that truck. So what do we know?
Check.
We know that Mr. Arbery was running back up Holmes when Mr. Bryan came back down, and he had to turn around at that blue mailbox. We don't see him turn around, but see how far he is at that blue mailbox? And he heads back toward the white truck. If he wasn't already in fear of Mr. Bryan and his Silverado, would he still be alive? Yes. But because of what happened over on Burford, because of the criminal attempt at false imprisonment and this aggravated assault, Mr. Arbery's dead. False imprisonment. You violate the personal liberty of Ahmaud Arbery. You unlawfully confine and detain him. Well, how do you do that?
That
Well,
is
you
correct.
chase him down with a Ford F-150
They're not arguing they killed
or
him
a
because of
Silverado.
race.
And they did confine and detain him on Holmes. Ladies and gentlemen, come on. We've looked at this. All right. What do we got? We've got Mr. Bryan chasing him up Holmes. Now, yeah, this line doesn't go far enough because what did Travis McMichael tell the police? I stopped a few houses down, got out of my truck and shouted at him, stop, stop. Now, he denied it on the stand, but that's what he told the police in his written statement, the one he had an hour to fill out, right? So Mr. Arbery got this far and had to turn back around. Then he goes back this way. Then he has to go back down this way because now he's turned around. Now he has to come back this way once Mr. Bryan turns around. He went up and down this street at least 4 times. I mean, come on. Confined and detained on Holmes. That's false imprisonment. Up and down 4 different times right there. You saw the night out video. You saw how fast they took off after him. I mean, Greg Michael's yelling, cut him off, cut him off, cut him off. Travis denies that he did anything to cut off Mr. Arbery. Doesn't even say he pulled in front of Mr. Arbery, but for some reason Mr. Arbery turns around and runs back. You decide what to believe. But what was he trying to do? What was his intent? He told you what his intent was. Our intent was to stop him. Can't stop somebody. United States of America, okay? People are free here. They had no authority to demand that he stop. And they're yelling at him, stop, we want to talk to you. And he's running away. That's the criminal attempt by the McMichaels on
Too many
Burglary.
bad
Now,
statements.
of course, we know
He's
the
probably
criminal
going down
attempt false
too.
imprisonment by Mr.
I
Bryan.
think Roddy goes down.
He pulled out,
It's too
pushed
many-
him, yeah,
When
shoved
jury
him,
starts
did
saying
whatever,
guilty,
got him into a ditch.
it's hard for them to start saying not guilty.
Now, those actions on Burford, did it put Ahmaud Arbery in reasonable fear of receiving bodily harm? Yes. So now what's he doing? He's running away from them. For 5 minutes, he's running away from them.
I think her style is good.
If
She's
they
talking to
hadn't
regular people.
Put him in reasonable fear of receiving
This is how
serious
you do it if
bodily
you're gonna talk to
harm
regular
so
people.
that he ran away from them, would he be dead? The answer is no. Therefore, that substantially contributed to his death. Because why? All right. Where did he go? He went up Holmes. Now, this whole thing of, oh, well, the reason he didn't really run out this way is Mr. Albenzi was down there with a gun. Nobody has x-ray vision. Mr. Albenzi had the gun in the pocket of his overalls, okay? And what do we know Mr. Albenzi did after all this? He went home. Remember? He walks back and he goes on home. I'm sorry, goes on home here. So this idea that Ahmaud isn't going to run this way because Mr. Albenzi is out there, we don't know what's in the mind of Ahmaud Arbery. Not at all. But what did Mr. Bryan do? Well, Mr. Bryan got in front of him and then went to back up at him, and that's when he turned up Holmes. Those are the words of Mr. Bryan. I pulled in front of him, I backed up at him, and that's when he turned up Holmes. Therefore, the criminal attempt at false imprisonment substantially contributed to the felony murder. Based on that alone, ladies and gentlemen, criminal attempt at false imprisonment, guilty. Felony murder for that on all of them. Mr. Bryan included, and the McMichaels, guilty on felony murder. So, but for his actions, would Ahmaud still be alive? If he had not helped to stop Ahmaud with his Silverado, would Ahmaud still be alive? The answer is yes, he would have been. That's all you got to think about is, well, what did he do to contribute to help the McMichaels? The answer is yes. Mr. Bryan played a substantial and necessary part.
What did he do?
of his
The
death.
answer is not
He is
yes.
responsible for the murder of Ahmaud Arbery. All right, so that brings us to self-defense. All right, I'm just going to go over this quickly. I want you to know what the basics are, the essentials.
Yeah.
Okay.
She's getting to
Self-defense really
this is all
applies to
again.
aggravated assault with a shotgun.
This is just
okay,
all
and
blah blah blah.
murder charges.
As soon as
So
she
what do we
gets
got?
to the citizen's
One
arrest,
can
that's
use
where the
lethal
bomb is going
force
to be
in
dropped.
self-defense, but only under certain circumstances. You can't claim self-defense.
She's not as sharp as she's been
if
throughout
you
the
are
trial.
the unjustified initial
Yeah,
aggressor,
but
meaning
it's
you
just as like-
started it.
I don't know. Like
You
today, it's
started
just kind of like we hear all this already.
Well,
or we heard
Ahmaud
all this
Arbery.
already.
If you're committing a felony against that person, once again, we're back to our convenience store armed robber. He doesn't get to defend himself against the clerk he's robbing. He doesn't get to claim self-defense. He's committing a felony. In this case, they committed 4 different felonies, including the aggravated assault with a shotgun. They started it. They do not get to claim self-defense. And then, of course, provocation. You can't force someone to defend themselves against you, so you get to claim self-defense. This isn't the Wild West. No. So there's 3 instances where the defendants don't get to claim self-defense, and they committed all of them. So once again, initially provokes the use of force against himself with the intent to use such force as an excuse. No Wild West. This is the important one. Cannot commit aggravated assault with a shotgun, with trucks, false imprisonment, or criminal attempt at false imprisonment. Any of those. Not justified in using force if you're doing any of those things. They were doing all four of them. And you're not justified in using force if that person was the unjustified aggressor.
I'm with you on civil.
You can't
It's just it's not as punchy as it was yesterday.
And they started this with their driveway decisions. So here's some main concepts. The defendants had to believe the deadly force was necessary. There were no other alternatives. Pointing a shotgun at somebody. There were a whole bunch of other alternatives to that. That belief must be reasonable.
Their cadence might be a bit faster
reasonable
too.
for everybody. That reasonableness applies to you. That reasonableness, there's no special exception for previous training in the Coast Guard or law enforcement. The reasonableness standard in Georgia applies to everyone equally. The danger to yourself has to be imminent, meaning I am about to get killed. Not some guy I've been chasing for 5 minutes is running at me. Can't use excessive force. The minute it's excessive, self-defense goes out the window.
That's true. That's a fact.
The defendant's reasonable belief must be what prompts him to use force. What prompted Travis McMichael to pull up that shotgun? He wanted him to stop. He was trying to get him to stop. Oh yeah, you're not going to stop for me and
The
my
excessive
dad?
force is a huge issue.
Up comes the shotgun. Now
It's
you're
like
going to
even
stop.
if the arrest was valid,
Okay,
the
you're not gonna
case law is
stop, you're
pretty
gonna go
clear
around
on
the
this
truck, that's
point.
fine.
Even for citizens arrest, it
He
has
goes
to be
in the
reasonable
shotgun.
force.
He's not afraid. He moved.
So if
even-
he was
forward.
trying to conduct a
Mr.
citizen's arrest, if
Arbery.
that was his goal,
He's still got excessive
forward,
force
Mr.
problem.
Arbery.
yeah,
Where's my gun?
he's screwed.
He's not afraid.
Yeah, so people, if let's
You
say
gotta
if he
act
was
out
a
of
cop,
fear. You can't be
a
acting
cop
out of
can't pull his
anger.
gun out for somebody just running.
But this guy
he's trying to
won't stop
catch.
and talk
You
to
don't
him.
do that.
We'll obey your
If
commands.
the guy did have a gun, you could do that, but
Okay.
Tennessee
Well,
v.
here's the
Gardner, what?
Well, let's see. Ahmaud was
Yeah.
wearing a t-shirt and cargo
Got it.
shorts that were so baggy, he has this big belt loop out here. Let's see what else. Didn't have a bag or a backpack. So, yeah, doesn't have anything that he's carrying. He was
I'm
running
thinking what
with his
she's doing
hands
is known
empty
as
at his sides.
overpromising the time. So I'll say
Ran
it's going
away
to be
from
2
them
hours,
for 5 minutes.
and we'll be done in an
Did not
hour.
have any
And you'll be
weapon.
so happy we'll be done in an
Nothing
hour.
on
You
him.
give me extra points for being done
Didn't
early.
say one word to them. Didn't threaten them verbally. Didn't say, oh yeah. Didn't say anything. And he had no help from anyone. So what's
Yeah,
there to
I
be
think she
afraid
said
of?
2 hours to make the jury leave yesterday.
He went this way, goes this way, he goes that way. And you see Travis McMichael
I don't
move
think the
down
jury's
to
going
the
to be
center
sad
of
if it's less
the
than 2
street
hours.
there, blocking his way.
That's what I'm saying. I think that's what she did.
He's trying to get away.
What that comment
and then,
said is
oh,
that
look, he's going to go
she
this
said
way.
2 hours
And he
because
does.
yesterday she wanted
He
the jury
goes
to leave
around.
to come back.
And what do you have
so
here?
it's going to take 2 hours. And today
Travis
I think she's probably going
McMichael
to take an
going
hour,
to
maybe
intercept.
give
that
us an
shadow
hour.
underneath
Okay, I
there-
thought it was going to take 2 hours.
It would be
I mean,
hilarious
you
if it
can
was
have
only
the
like
stills
20
back
minutes
there.
long.
You printed some of them out.
Lol.
That shotgun is pointed
It's a nice
right
tactic,
at
though.
him.
These are tactics, baby.
Right at him. Okay? So when he gave the police that story about, oh, it was at Port Arms, and he was striking me and hitting me and striking me and hitting me, and I finally, had to do this. That's what he told the police. A bunch of lies. Shotgun, shadow right here. Okay? Here's the other thing, ladies and gentlemen. Lawyers aren't good at math. I don't trust you guys are. What did the ME say?
Truth.
This arm on Ahmaud Arbery was 26
Preach.
inches. This arm on Ahmaud Arbery was 25 inches. And the barrel of that shotgun is over 28 inches. Do the math.
Lawyers aren't good at math.
Did he hit
Can you
him?
do
Did
the
he
math?
punch him?
Oh,
Did he
Lord.
strike him? When the shotgun's like this, it's easy. Do the math. This is what Travis
Yeah, I
McMichael
don't like
did.
that one.
There's
Yeah.
no fear here. There's only anger. Remember, it's a standard of reasonable beliefs.
I know she's
That
trying
the
to talk about the
force
malice murder,
Used
but I
as
would still.
necessary.
I'm not guilty on malice murder.
Do you really
I'm sorry.
believe he had no other choice but to use his shotgun? Is that what you really believe? No other choice. What are the alternatives? Well, the first alternative is don't start this. I'm going to tell you something. My husband, he always tells this to our three nephews, David, Ben, and Sam. And what he says is there's some rules for life. You know what those rules are? Don't go looking for trouble because you will find it. and it is not going to turn out the way you think it is. What he's really saying to them is, don't be that guy who starts the bar fight and goes, let's go out in the parking lot. That's what he's really saying to them. But it's a life rule. You go looking for trouble, and what's going to happen? So don't leave the house. Here's an alternative. Call the police. Don't chase down strangers to confront them. Don't go after pedestrians in your truck. I mean, common sense tells you, you pull up in a truck on somebody who's like a pedestrian who's out for a jog. I mean, I don't know, are any of you runners? You ever had a strange truck pull up and have some people start yelling at you? Would that startle you? I don't know. We don't know what was in the mind of Ahmaud Arbery. But, I mean, what do you think? Did it cause some fear for him? These strange men pulling up in this truck and then not relenting and not backing off? This was 3-on-1. How about some empathy? Remember leaps? Listen, empathize. Where's Travis McMichael's empathy? Where's Fred McMichael's empathy? Where do they go? You know, wow, I wonder what I'm doing to this other person. I wonder what it looks like from their point of view. I wonder if we might be scaring or startling this person. I wonder if it may be so bad that they might react in a negative way. Where's the empathy? How about don't bring a shotgun with you? This is really easy. Call the police. Because what did Officer Rash want? Remember Officer Rash? He said he wanted them to be witnesses. I mean, so call the police. Follow behind Mr. Arbery at that 2 miles an hour. Where's he going to go? They could have followed him all the way back to Fancy Bluff and Boykin Ridge. On the phone going, he's turning left. He's turning right. Ooh, okay. That was a real easy choice, but did they choose to do that? No, they confronted him. They chose to confront him. They didn't need to. They didn't have to. I mean, they could have followed. I mean, he's a jogger. How fast is he going? Don't point a shotgun at people unless you're going to kill him. Don't point a shotgun at people unless you're going to kill him. How do we know he intended to kill him? He pointed a shotgun at him. How about you stay on the driver's side of the truck? Don't go around the front of the truck. Real easy. All right, so let's go ahead and take a look at citizen's arrest, because this is really
Here we
important.
go.
The law of citizen's arrest. Okay?
This is where it closes.
So
This is
first
the
off,
close, people.
the defendants never ever said citizen's arrest. They never ever said we're making an arrest. They never said we saw him commit a crime. So ladies and gentlemen, where in the world did the citizen's arrest thing come from? Because it didn't come from the defendants on February 23rd, 2020. Where did it come from? So what is the law? A private person
Facts.
may
Good
arrest
point,
an
John.
offender if the offense is committed in his presence. What does that mean? Right here, right now, I saw you commit an offense. Okay? I saw you criminally trespass on that property right here, right now on February 23rd, 2020. I saw
teaching
you
them the law
commit a
now.
burglary. I saw you commit whatever crime it is, it's in your immediate presence. Or within immediate knowledge. Okay, we talked about that. The guy at Walmart is not standing next to the shoplifter when she shoplifts, but in real time, what's he doing? He's watching it. We're not talking about videotapes. You can't watch a videotape from November and then have it in your immediate knowledge. Okay?
Oh,
Remember,
I didn't
the
really
judge
like
is
that
gonna tell you it's
juxtaposition.
synonymous. It means the same
No.
thing. Meaning
With the
in your
watching on
presence
video
or immediate
for
knowledge.
Walmart, and then
It's
we're not talking
immediately
about
you know
videotapes
because
slightly.
you saw it. That's what that means. That doesn't mean watching a videotape on February 11th with Officer Rash in front of 220 Satilla Drive. That's not what that means. A private person may arrest an offender if the offense is committed in his presence. Did Ahmaud Arbery commit any offense in the presence of any of these defendants? The answer to that is no. Boom. Citizen's arrest is gone. But yes, I am going to continue because there's some more caveats. If the offense, the one that was just committed in your presence, is a felony. Do you get why they're trying to make Ahmaud a burglar so desperately? Because if all he's doing is criminally trespassing.
Again, I don't like to interrupt closings, but this is not an accurate statement of the law that the court is going to give this jury. The parenthetical is not accurate.
The parenthetical is mine. totally mine.
Well,
Okay?
I've made an objection, though. I'm asking for a
Let's just
rule.
explain. Yeah, the parenthetical is what the state is arguing. The rest is the charge of the court. The charge is going to be provided to the panel. And with the same explanation I provided a little bit earlier on what the law is going to be, the court is going to provide you the law of the case. Counsel, you may proceed.
Thank you. So, okay, the first sentence is, a private person may arrest offender if the offense is committed in his presence. Okay, you can arrest if the offense is committed in his presence. If the offense, and that's my parenthetical to remind you, if the offense, we're talking about that offense, the one that was just committed in your presence is a felony, and the offender is escaping or attempting to escape right then and there.
Judge, that is not the
No.
law that the court's going to give, and we've had this discussion. We've
It's a
talked.
He's trying to
in the
stop it.
statement of law, we would object.
I join in the objection.
It's noted.
You'll understand this is my argument. The judge is going to give you the law, right? And he's going to have it written out for you, and he's going to read it.
They're just trying to
This is
break
the
it up.
state's argument.
They know this is bad.
That the offender is escaping or attempting to escape. The state's position is that what that means is I saw the crime. I can't chase after the person. I just have to try and arrest them right there. But if it's a felony, and if they're escaping, they're running away, I get to chase after them. I don't get to chase after them unless it's a felony and they're trying to escape. All right? A private person may arrest him upon reasonable and probable grounds of suspicion. That's the state's position.
We have to object and have a conference with the court.
No, we're going to let the state continue. We talked about this in the charge conference. The objection is noted.
Mm.
Move from this trial based on the incorrect statement of the law.
We join.
They desperate. They desperate.
Ladies and gentlemen, if you could please just go ahead and take a step
They
to
are
adjourn.
desperate. Desperate.
All right, let's go.
They're saying, stop this. Stop this. She's killing us. She's sending us to prison. Stop this now. This is what you want now. She's like, please. No. The law is what it is, though. They're, you know, what can you do? They're just screaming. They know, but they know it's over. And they knew this was coming. They knew this was coming.
All right, the court had a charge conference Friday. I was provided a bunch of arguments over the weekend that we are making part of the record. So I understand the objection is being made to the law. I've indicated the law is going to be provided to the panel. I've indicated the court's position with respect to the law. So with that, I'd like to get the closing argument done, but I'm more than happy to hear the motion for mistrial and proceed from there.
Your Honor, based on the final draft of the charge that the court provided us, I guess yesterday morning, the court is going to charge that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies, during escape. If the observer fails to make the arrest immediately after the commission of offense or during escape in the case of felonies, his power to do so is extinguished. That's not what the state's arguing. They're arguing and it's a clear misstatement. The court should simply instruct the state not to argue an incorrect statement of law rather than putting the burden back on the jury to understand what the state's saying, what we're saying, and now what the charge is saying. The court has the power to do so and should do so.
What is he saying?
In further support of the motion for
That doesn't make any
mistrial, on
sense.
behalf of Greg McMichael, obviously, this is the last word by any counsel in the case.
You're not going to
and
get a mistrial
to
out of
argue the
that.
state's
You'll
And
at
she's-
best
she's
get a
perfectly
corrective
fine with
instruction
their
right
doing.
now.
But
is to
but
argue
she's
the
not. What she's saying is
facts
not
and
wrong
evidence
at the
as
point.
the
No,
law
that's what my
applies to
understanding
them, but
was
not as
of what the
Yeah.
judge said.
statement of the law applies to
Yeah.
them,
So
and
unless
we
something
can't
not a
changed
change
since I
mistrial.
last paid attention.
except by
They're trying to
making
annoy
an objection
annoy
with an
the
incorrect
instead
law
of the
being
and
given to the
they're
jury
trying to
by the state.
still keep this
So
this
there's no way we can
facade that
fix
there's two
it. We're
separate
asking the
clauses,
court
which is
to
not.
fix it, not by simply saying to the jury that the law is going to come from the court, which it will, but that this is a misstatement of the law and this argument is improper.
You join?
Thank you, Your Honor. Yesterday, the defense got up here and argued their interpretation of the law. And I didn't object at all because I knew it was their interpretation of what they believe the law to be. They went through the whole probable cause thing. They called him a burglar. They went through everything. The state didn't object because I understood that this was their position of the laws applied to the facts. I've just made it clear to this jury, and I will again, that this is what the law is, and this is how you apply it to these facts, and this is the state's interpretation of how you read this law, just like they gave their interpretation in their closings yesterday. So we ask that you deny the mistrial.
Onward. Well, no.
You can argue the law, you can't argue a misstatement of the law. The state never told the jury, this is my interpretation of law until we objected.
Okay, but that's
Well, I think
why
that's
it
what
was.
was explained in the parent.
I mean, you're going to
Yeah.
best get a
The
correct
state
instruction on
doesn't
this.
I will. State needs to clarify that this is the argument based on the law that will be charged and with the law that will be charged, and make sure that we're clear about what the law is that's being charged. There was a debate about this on Friday, and I'm not going to reignite that debate in front of the panel.
We're fine with what the court's decision was on the contemporaneousness of the events. The charge is great. It's the state's argument about
Charge
what
is
that
great,
means
isn't it?
that's flawed,
Yeah.
and it's fatally flawed.
The state has the right to, just like the defense had the right to argue that what escape means is escaping whatever this temporal period is. I understand the state to be arguing the same thing in a much more limited temporal period. I think the state's got the right to do that. The state needs to be sure, though, that it's clear that that is the argument that is being made as opposed to what the law is. And I think the charge is very clear about that. So the motion for mistrial is denied.
I may add that the state is arguing that the felony for the second sentence has to have just occurred in the immediate presence of the person seeking to
Yes.
arrest the escaping felon. That is absolutely a misstatement of the law. Even as the court agreed to charge it, that's not even correct.
That is a statement of the law.
The second sentence does not require the felony to have occurred within the immediate presence contemporaneous with the escape and the chase. That is not the law. That's not the law the court agreed to charge.
That is the law, though.
Your Honor, you're charging the statute. And the statute are those two sentences. The state's interpretation of that statute is if the offense, well, that is, the offense has to be committed in your presence or immediate knowledge. If that offense is a felony. I mean, that's what it says. If that offense, well, it's referring back to that first sentence. And the state's interpretation is, then that means that felony had to be committed in your presence. The person had to be escaping right then and there. And that's the state's argument to them, that they never saw anyone escaping from a felony that had been committed that day.
That's what it is. That's essentially what it is.
Yeah, that's not what was in it. So the escape, the second sentence, the court
Right.
was charging, which I understood was agreed to, was that if it's a felony and there was an escape, that's the
Okay.
temporal issue that we're talking about.
Correct.
Then those steps can be taken to detain or arrest the individual.
Correct.
What I understood the defense was arguing is that this temporal period stretched over
2 weeks.
some time.
Yeah.
What I understood the state was arguing was no, that temporal period is
It's
limited
just
to
for that
what
day.
had occurred there, the escape. The word escape
Correct.
was he was escaping from whatever may have occurred that day.
All right. Yeah.
Yes, that is what we're arguing.
Okay, well,
Correct.
that's not what I'm hearing then, because what I'm hearing is, well,
What are you
the
hearing,
state
Judge?
limits its argument to that's what the second sentence refers to, an escape, that limited temporal period, then that's
That's what
permitted.
she's-
That's what we talked about in the charge conference.
Yeah. That's what. Yeah. That's
I don't think
that's
that
exactly
is
what it is.
what we argued about by email and all the rest, Your Honor.
Well, that's what I remember, that's what I'm saying.
Yeah. The judge. Yeah. That makes sense. So
Hey,
obviously,
for me to
people.
Step out just for a second.
No, it's
I
overruled.
will not disturb the jury if they're back by the time I get back.
I could also
So,
use the bathroom
it's been overruled.
before he got you, and that's what Mr. Hope was looking for.
Let's just take literally 5 minutes, and then we'll get back into this.
So what he needs 5?
Yeah, they use 5 to go to the bathroom. They want to break this up, obviously. They want to break up that flow because they know where it's going.
Now, now Andrew Bianca on Twitter is saying, and he's quite right, that the law itself is from the court, and the you can't have it where the jury has to decide what the law is. You have
No.
to be in terms of what the law actually is. Now you can argue interpretation to some degree,
Mhm.
but the law itself. So like whether this is an and or an or, for example, which is what law of self-defense was saying. I mean, that's not something that goes to the jury. Is this
No.
and or? And this was going to a discussion we were having where I didn't really have a firm position on it, but I was saying, I think maybe the judge is wrong on the interpretation because these two sentences, to my mind, read disconnected.
Mhm.
In the case of sentence 1 says, basically in the case of a misdemeanor, there's an implicit if in the case of a misdemeanor or felony that's committed in your
Mhm.
presence. And then sentence 2, if in the felony, right, then this applies. So I think maybe the right read is disconnected. Now, the case law appears to support a connected reading. So
Yes.
I'll defer to that issue, that it's connected. And if it's connected and you need both those things, okay. But then in the second half, there's still a debate. It's like with the escape. It's like, is there an and or an or there too? Is it a felony and they're escaping, a felony or they're escaping? So the judge really needs to, what the judge
No,
really should be doing coming now is saying, okay, let me just remind you again what the law is. Just read it to you now. It's in the jury instruction. I'm going to read to you in a second anyway.
Mhm.
So let me just read this portion of it to you right now, just to clarify that. And this is the law, and go forward. So that would be how I think the best way to solve this problem is.
Yeah, they during the charge conference, that's when they had this big blow up about this. And in the charge conference, the judge pretty much made it simple. If somebody commits a felony that day and they escape, first, the judge said the second sentence, what the defense is trying to do is say the second sentence kind of neglects the first. So the first is the requirement for any offense, right? Because it says the offense. An offense is either misdemeanor or felony. So for any offense, these are required, right? So that now is saying the requirement for any offense, felony or misdemeanor. The second sentence is saying, but we're also narrowing if a felony and then the
Right.
person is escaping, you can chase them, right? So
Right.
so those sentences are connected in that way. But now, what the judge said, what that means in this case is that if you're there and you witness, right? If you witness a felony, if you witness a misdemeanor or felony, you can arrest the person right at that moment. But if the person is running away, misdemeanors you can't chase. People who are committing felonies you can. But again, that escaping piece doesn't negate the requirements from the first sentence. It's just a limitation on misdemeanors. So it's not like if it's a felony you can just chase them, but it doesn't have to occur in their presence. No, you still have to meet those requirements. But if they're escaping, then it allows you this extra ability to chase people who've committed felonies. So that's what happened. And then this contemporaneously piece of it is that it has to happen within that same amount of time. So 2 weeks later, you can't chase someone that's escaping, right? 2 weeks later, you can't say, well, this guy's escaping from a crime 2 weeks ago. And that's what the defense doesn't want them to see.
Yeah. It might be correct, but it could be perceived as slightly odd that if it's just purely a misdemeanor and they're
Mhm.
escaping, you have no right to continue citizen's arrest on any level. So I don't know how that would apply, for example, to a shop who has a security guard. So if they start trying to run, you confront them in the store and they start trying to run, are you not allowed to try to stop them anymore? I mean, that seems
Yes,
to be the implication.
if they are escaping, right? So if you have a shoplifter, they make it to the door and they start running down the street. If it's a misdemeanor, petty larceny, that security guard can't chase them. If the person then punches and grabs the money out of the cash register, that's a felony robbery, and then runs down the street. The security guard then can chase that person. So that's the difference between robbery, felony, and petty larceny, misdemeanor. That's how the law reads. So this whole And then if you don't catch them within that day, right, within that time frame, if the person, both the felony guy runs and you don't catch him, then you see him tomorrow. You can't then arrest him for that felony the next day because your power to do that has extinguished. That's the way she should be explaining to the jury. That's the way she should be explaining to the jury. That's what the judge said. Now, I understand she's just doing a bad job of putting it together, but that's how you do it in a simple way.
Yep. She doesn't seem quite as organized, and I'm slightly surprised because she obviously had the evening to try to put together some sort of outline or something. It feels almost like there was no break at all between the defense and the prosecution.
Yeah, and this is what I'm talking about, form and substance. I think what she failed to do, and this is a good, let's chop it up, let's break them up. I think the defense is doing a great job in hitting those objections because they knew this was coming and they knew this point they wanted to object to. But but the issue is the judge gives you the law, and she has to now explain how this law, how like my closing for this or my rebuttal for this would have been different, right? There is no contention here with this case, right? The defendants have said this didn't happen in the present. They didn't see anything. Fine. So they don't fit the requirement of the first part of the statute, right? So there is no citizen's arrest. They have said themselves they don't fit the first part of the statute. And if they don't satisfy the first part of the statute, right? An offense, you must have this. They said we don't have this. Then they couldn't have been making a valid citizen's arrest.
Right.
And that's from their own statements. Now, if you want to go to the whole escape thing, you can explain, well, the escape issue, that, and you explain it that way. Well, the escape is if it happens at that. And that's what she was saying. The escape, if it happens today, then yeah, you can chase them, but you can't chase them 2 weeks later. And then she should just read the charges because she already has a jury charge. She should just read it because and extinguishes. And that's how you wrap this up and you give it to the jury because there's no way they can find that this is a viable citizen's arrest with that charge. With the charge the judge wants to get, there is no way they can find that this is a viable citizen's arrest. And that's what the defendants are the defendants want to confuse the jury. They want to have the jury think, oh, well, maybe it's possible, it's not a viable citizen's arrest, but it is.
All right, so ready to proceed?
Upon reasonable and probable grounds of suspicion is probable cause. There's no doubt about that. If the state claims, as you were describing, what is the point of reasonable suspicion part of the second statute? It makes no sense, but it's not reasonable suspicion. It's probable cause for an arrest. It's probable cause for an arrest. I understand people want it to be reasonable suspicion, but it's not. Because reasonable suspicion, that means that a crime hasn't been committed, right? So you're illicitly, if you're saying you should arrest people for reasonable suspicion, you're saying you should arrest people for crimes that you don't know have been committed.
Yeah.
Probable cause is a crime has been committed, so you have a person who's committed that crime. Reasonable suspicion is I suspect someone of committing a crime, so I'm arresting them. That makes no sense.
No, that's definitely not the law. Never has been.
Yeah, that's why you don't arrest. That's why even police officers can't arrest people for reasonable suspicion. And if I was the defendants, I'd be raising hell too. I would be raising hell too. Is probable suspicion enough to detain? No. Probable cause. Whenever you say suspicion, you don't have enough. And understand this: regular citizens can't detain other citizens. You can't. Police officers can.
All right, ladies and
Citizens
gentlemen,
cannot.
welcome back. Thank you for your patience. I understand we are ready to proceed.
Yes, thank you, Judge. Ladies and gentlemen, like I said, the judge is going to give you the law. He's going to read it to you. He's going to give a copy to you. So you're going to have it back there with you. I encourage you to read it. So let's get back to where we were, the law on citizens arrest. Where we are is a private person may not act on the unsupported statements of others alone. Okay? All right. So what that means is, once again, we're back to, did the offense happen in your immediate presence or in your immediate knowledge? How do you get immediate knowledge? Meaning immediately it happens, synonymous, right? So that isn't rumor, gossip, hearsay that a crime has been committed or that some other person thinks this other person committed this crime. You can't base your citizen's arrest on that sort of stale information from unreliable sources. That's not what you can do. Okay? You can't base an arrest on gossip alone. Facebook does not alone give you probable cause to go arrest somebody. Rumors in the neighborhood do not give you probable cause alone to go and arrest somebody. That's not what immediate knowledge is. A private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies, during the escape. Okay, so what's that mean? Why is warrantless highlighted? Okay, because a citizen's arrest is a warrantless arrest.
That's
You
true.
don't have an arrest warrant that, you know, a law enforcement officer has sworn out before a judge at all. This is a warrantless arrest. And so for the warrantless arrest under citizen's arrest, the arrest must occur immediately after the crime was committed, or in the case of a felony, during the escape. That means the person's escaping, you're chasing them, and you have to arrest them right then and there. That's what that means. Now, remember, the defense got up here and said, well, of course, how would a law enforcement officer ever arrest anybody?
You got to put a judge's robe on.
Here, and then they
That's what
arrest
the
them
judge
later.
says.
Well, we all know that law enforcement officers go out and get
You're
arrest
arguing
warrants.
against the judge.
Okay, that's what they do.
I do want to. The reason why I'm stopping is just for one thing. I understand people are saying, I read the statute this way, right? I read the statute this way. That's what's called a mistake of law, right? The way you read it may be correct, right? It may be the correct reading of it in your own interpretation, but the judge tells you what the law is, right? The judge is the one who's authorized to interpret the law. So no matter what you believe how it read, it's the judge. And this judge has told us what the law means. That's their role. So,
And if the judge is
Arbery versus
wrong,
Madison.
if the judge is
Then
wrong
he'll
in
be
the law,
appealed.
that's what appeal courts are made for, man. Appeal courts appeal courts reverse judges every day.
Yes.
And
Yeah.
judges screw up on the law. So maybe he is screwing up, but his
Maybe he is.
interpretation seems to be, I mean, he's done his due diligence, he's done his research, and he seems to have the support. So, you know,
They go ahead and they
And if he's
they
wrong,
know-
they'll have a hell of an
they
appeal.
know Linda has
Yeah.
been committing shoplifting. Okay, they get called, they witness her.
I'd
she
write the
runs out,
appeal.
Okay,
I'd give it a shot.
they don't arrest her
I
that
would,
day.
yeah.
So what does the officer do? He takes out an arrest warrant for her. That's how she gets arrested later on the arrest warrant for shoplifting, because she wasn't arrested by the law enforcement officer on that day when he saw her shoplifting. He takes out a warrant and arrests her later. So that answers that question that the defense brought up. All right. Law and citizen's arrest. If the observer fails to make the arrest immediately after the commission of the offense,
Hell yes, Salty.
or during escape in the case of felonies, his power to do so is extinguished. Okay? So, when you're in
Here
the
it is.
store and the woman's shoplifting and you go to do a citizen's arrest, you have to do it right then and there. She comes back in the store 4 days later, yeah, you can't arrest her. You can't do a citizen's arrest 4 days later. It has to, if you fail to make that arrest immediately after the commission of the offense, you have no power to do a citizen's arrest. In other words, this is what we're talking about. We're talking about citizen's arrest for emergency situations.
Judge,
Emergency situations.
I object to this interpretation, which is a misstatement of the law.
We join in that objection.
I think they're doing everything they can. I
noted.
think this is
This is the argument that's being made.
they got to do whatever they
already
can to stop
addressed
this.
that.
Except that it says law on citizen's arrest, not the inference, as the court was making clear to the state.
Good
Not their
part, Alex.
interpretation, but the law, it says.
You want me to tell the jury again? I'll tell
This-
them again.
Maybe semantics with
fun.
the slide. I don't know, and I have not gone through the slide. The law of the case will be provided by the court. All right? This is argument. This is the state's argument concerning what should be the facts of the case and how to apply them to the law. The slide, to the extent that it indicates that this is the law on citizen's arrest, is again, as I understand, demonstrative. The court is going to provide that. Ms. Doncaster.
Thank you. It says, in other words, this is me sort of summarizing it for you. This is the state's argument. You all understand that, right? This is just the state's argument. And the state's argument is that citizen's arrest is for emergency situations when something's happening. They are right in front of you, and you want to go ahead and act as a citizen and arrest the person because you just saw the crime happen. That's what it's for. So what we have is, I'm sorry, it says law and citizen's arrest. This is once again a summary slide done by the state. This is the state's argument to you that the crime is committed in your presence. Immediate knowledge is not the unsupported statements of others alone, that a private citizen's warrantless arrest must occur immediately after the offense. And if it's a felony and the offender is escaping or attempting to escape, you can chase them and then make your arrest. Okay? That's it in a nutshell right there. All right. So we're going to apply that law to the facts of this case, right? So what crime are we talking about that they thought he had committed? Was it clear to you at all, based on their closing arguments, what they were talking about? All right. Well, it can't be October 25th, 2019, because Ahmaud was on the dock, and he didn't take anything. All right? So, what do we have? Well, we don't even have criminal trespass, because criminal trespass is when you enter on the property of someone else to do an unlawful act. All right? You decide. Did he enter on to 220 Satilla Drive on the dock to commit an unlawful act? Well, go ahead and look at the video. Didn't touch any of that stuff. Didn't steal any of that stuff out on the dock. Wandered around and looked around on the dock. All right? Let's talk about Larry English here. Larry English was not concerned about people there in the daytime. He didn't bother to even collect those daytime videos. Kelly Parr told you, yeah, there was a Sunday, I saw Ahmaud there in the doorway. You know? We don't know if it was December or January. Larry English couldn't have cared less. Might have been instances of other people there during the day, but he couldn't remember because he didn't care about people coming on the property during the day. What did he tell you? He told you he could remember his subcontractors were there, the kids came over there, and Mr. Billy. I don't know who Mr. Billy is. He would sometimes shut off the video cameras and not turn them on for days. Remember in his deposition, he said, yeah, I'd shut them off because they kept going off because people were over there and I'd forget about them and not turn them on. Okay, so he's concerned about his property, but he's concerned about liability because of those kids. He doesn't want one of those kids falling off his dock. Per Larry English, he's a contractor. And by the way, Larry English is the one who referred to it as a construction site. Remember, during his deposition, he called it the construction site. In his experience, it's very common as a general contractor to have people come in and out of the construction site. And what did he tell you? He told you this in his deposition. Nothing had ever been stolen from the construction site in all of 2019 and the first 2 months of 2020. Let's be really, really clear. This whole boat thing, that's a red herring. All right? Total red herring. Nothing had ever been stolen from the construction site. And you can see how much stuff is in there. You got lumber. You got all this stuff. Mr. Arbery never shows up with a bag, doesn't back a U-Haul up to it and start loading out that big saw or anything like that. What does he do? He wanders around inside for a few minutes and leaves. That's all he does. But during late October or the beginning of November 2019, we have no idea what the actual date is, Larry English climbs up a ladder and looks down into his boat that's parked there and goes, oh my gosh, my stuff's missing. Okay. He notices it sometime in the end of October, beginning of November. He can't even tell you what date that was. Okay, and he calls Rash. He goes, okay, Rash, what do I do? And he talks to Rash about this and says, well, I don't know when the stuff was stolen. I don't know who stole it. I think it was my subcontractors who stole it. They're the first suspects.
Yeah.
But he also notes that the boat had been back and forth to Douglas where he lives during this time frame. So Larry English, when he's talking to Rash, now knows, I don't know when it was stolen. I don't know who stole it. I don't know where the boat was. And he decides to not even get the police involved. Because what does Rash say? If you want to report to the police, what do? Call the non-emergency number and an investigator will come out and take a report from you. We'll interview you. Figure out what everything is. But what are the suspects from Larry English's point of view? Well, it's his subcontractors. It's the looky-loos, the white couple with the bag. I mean, that's from the 911 call. He thinks they're the people. And then it might have been the 4 teenagers in Douglas. So it can't be sometime in October, November when Larry English noticed the items missing from the boat. okay? Because we don't even have enough for Larry English to call the police and even do an investigation into this, because he doesn't know where the boat was, much less what date the stuff was stolen off the boat was. We don't know what date this took place. So he never told Travis McMichael, never spoke to Greg McMichael, never talked to William O'Brien about any of this boat thing. Okay? Travis McMichael knew the boat thing from gossip, unreliable source, stale information. Who
Wow.
told it to him? He told you. His mother. Greg McMichael knew about
Nick.
this from Officer
Hey, Nick.
Rash. And what did Rash
Hey,
tell you?
what's up, man?
Yeah, I went down.
Oh,
and
so
But I
Greg
gotta
Right.
McMichael told
hold
him
on, Nick.
that
I gotta
Larry
turn you
English had stuff
down.
stolen off his boat, and that he suspects his contractors. They knew better.
Go ahead. Sorry about
How
that.
you doing? How you doing, Civil?
What was the intent?
So what are you
And
thinking
Officer Rash told
about?
you, my intent here was for
what do you
Greg
think about the
McMichael
case,
to be
I
a
guess?
good witness for the police.
Oh, I think that was a body blow. The last decision
He's
and what
supposed
they're
to be a
arguing
good
now over
witness.
the.
If he sees the guy over there,
I think it's going to hinge on whether or not the
911. And
or
then
obviously it's
he's
going to hinge on
supposed to
whether or
go,
not
hey,
they
he
can
went
do the
this way,
citizen's
he went
arrest,
that
or
way.
if they can't,
That's what
I
he's
don't
supposed to
see
do.
any
Be
recovery.
a
from
good
that.
witness.
Yeah.
Greg offers his contact information to
I
Officer
don't see him
Rash
getting out of
to
this.
give it to Larry English, but Larry English never gets this text. He totally ignores it. Never makes contact with Greg McMichael. Never authorizes
And then
Greg
even if
McMichael
they
to act
can
on
do
his
the
behalf
citizen's
at
arrest, the
all.
excessive force thing is still a real
Well, Larry English,
problem.
it's completely reasonable. I mean,
So
look at this. This is what the actual owner of the property wants to have happen. This is what the owner wants. Find him, talk to him, and tell him not to come back. Okay? That's a totally reasonable response.
I do
Completely
wonder,
reasonable.
because
Just
people
Officer Rash,
sometimes,
just
the jury,
tell the
they
young
always
man
ask
to
a
please
jury,
stop
you know, do you
coming around
take the
property.
testimony of a
Because what
cop
happens? My blink alarm thing goes off, and then I have to
seriously
call the
than that of
police,
just
and then I
a
have to call
citizen?
Diego Perez.
Question,
and
she
this is a
said,
real
well, you can't arrest
hassle.
somebody
He
based
never
on what you
takes
saw on
anything,
Facebook,
never
right?
steals anything.
Well,
But my
okay,
camera's
but
gone off,
these
and
were
you just tell him
cops
not to come back
saying,
anymore.
you know, hey, we got to keep an eye out
What did
for
Officer
these
Rash
guys.
tell
So
you?
I wonder if they're going to
One of the
go
last
for that
questions
argument. I think it's
Officer
a long
Rash was
shot.
asked on the stand. What did he say? Well, if Larry English had called the Glenn County Police Department to report the theft of items from his boat, what would have happened?
Yeah, you can
An
do that.
officer
That happens all the time.
would have been assigned to investigate the case, meaning he would have interviewed Larry English. What would he have said to Larry English? Sir,
Not for a citizen's
what was
arrest.
taken? When was it taken? Well, Larry English wouldn't have been able to say when.
Call the cops.
And who took it? Well, it was my subcontractors, I think. But then there was this white couple,
Yeah.
I think. And by the way, I think they're living under the bridge. And, you know, I don't know. And then there's this young man who keeps coming in, but he never takes anything. So this idea that Ahmaud would be a suspect, he's a suspect along with
Interesting
a whole bunch
hypothetical.
of other people. Okay? So here's the problem. If you're a suspect and you're a suspect and you're a suspect, the police don't automatically go, I'm going to arrest
you're a
him.
suspect, and
I mean,
you're a
that's not what they
suspect, and
do.
you're a suspect.
They actually investigate it, right? Like,
No,
there's
well,
law
she's
enforcement
right though. If you have
officers.
multiple
I know.
suspects,
So the
you can't just point
idea
one and say, I'm going to arrest
would
you,
be
right?
that an
You gotta
officer would go and
investigate.
look into it. That's
But you don't
exactly
have
what
the
whole
Rash
whole
said on the
thing,
stand. Do you remember
it
this?
wasn't really
He said,
working.
Ahmaud might be a suspect, but he would look into it. We don't even know when this stuff was stolen. Ahmaud would not have been automatically arrested just because Larry English made contact with the police. There would have been an investigation.
That's true. Even
That's
a police
what
wouldn't
Rash
have
told
arrested
you.
him.
Rash, an actual law enforcement officer with a badge and a marked patrol car. So then we got the white couple with the bag. He calls the police on December 2nd. They're the suspected boat thieves now. Remember, even on December 1st, he's calling the police going, yeah, these are the thieves who stole the stuff off my boat. I want you to go and check them out. Now, here's what's really important. Larry English called the police and said, please go check out the white couple. They're homeless, living under the bridge. He did not go himself to confront the people under the bridge. I want you to compare and contrast this. Because what do we know about Greg McMichael and Travis McMichael at this point in time? July 13th, they went down and confronted the homeless man under the bridge with their guns. And then called the police to tell them about it, that he's a shady looking guy. February 11th, Travis McMichael runs home, tells his dad, they get their guns, and they head back down to 220. He says, I'm calling parked in front of 220. All right? Where's Greg McMichael at that time? He's inside with his gun, about to run into Diego Perez, who's inside with his flashlight and his gun. neither Diego Perez or Greg McMichael bothered to tell Officer Rash that they had both
Some
been
more
inside
conversation.
already with their firearms on February 11th. Did they? Nope. And you'll note that the 911 operator stayed on the phone with Travis McMichael the entire time until Officer Rash arrived. That's important. Stayed on the phone the entire time so Travis could keep reporting what he was seeing. So now November 18th, 2019. They don't know anything about November 18th, 2019 until they're shown some videos on February 11th of 2020. So they don't even know about this. And it can't be December 17th, 2019, because nobody knew about that at all. Even Larry English, I don't know. I found these on my phone. I never paid attention to them. Police weren't called. Nothing happened. Okay, but what do we know? Okay, a couple of things. Let's look at this. I want you to watch this. What's Mr. Arbery doing? More importantly, what's Mr. Arbery not doing? All right. Here's the thing. All right. I'm gonna do this. I'm really scared, but I'm gonna do it. It's pitch black. It's pitch black. I'm in the house. I can't see. Okay, I know there's a table. I seriously do. There it is. Okay. Did you see Mr. Arbery do that? Did you see him do this? Did you see him run his shin into anything? Did you see him run into any of this furniture or this equipment? They keep claiming it's pitch black in there. Does he look like he's acting like it's pitch black? Okay. No. I don't know how he's seeing. I don't know if it's the street light. I don't know if it's the moonlight. I don't know if it's a combination of those things. But for him, he can see what's going on inside. On here. Just skirted that lawnmower. Didn't run into it. Didn't bash his elbow on it. And here's what we know Mr. Arbery did on December 17th. After he went in there for a few minutes and looked around, didn't take anything, didn't damage anything. This is what he did. So, can't be
crime,
February 11th, 2020. That's not the crime we're talking about that they're trying to do a citizen's arrest for. Because a private citizen's warrantless arrest must occur immediately after the offense. If you fail to immediately arrest, you can't arrest later. Okay, and what do we have here? Well, we know what we have here. We have criminal trespass.
She's circling right back to this.
most, according to law enforcement officer Rash, who then said it was loitering and prowling. But first off, I want to address this. Empathy once again. Where's the empathy from Travis McMichael? Travis McMichael's point of view is, I pulled up and I got out of the car and had a confrontation with this guy because I was about to say, what are you doing here? And then he put his hand near his pocket and then I jumped back in my car. Well, okay, let's think about this. Empathy. Do Ahmaud's actions afterwards, does it look like he thought he was just in a confrontation when he walked into the house? On February 11th? What did he do when he walked in the house on February 11th? Walked in, wandered around, looked around for a few minutes, and was gone by the time Diego Perez gets over there with his gun, right? So what do we got? Does it look like he just saw someone in a car out front and it was no big deal to him? I don't know. I don't know what he's thinking. I have no idea. You saw the video. What does it look like from the video? Is he in there hiding? Is he in there crouched down? Or is he just wandering around as usual inside? Remember, no one had ever told him to not be on that property. So the thing is, what you're saying to me is you're going, but Linda, the defense got up here and said he's a burglar. He's a burglar, and he committed all these burglaries. Well, why are they saying that? Well, because they want it to be a burglary so that it's a felony, so that if he's escaping from that felony that he committed, that burglary, they can chase him down. But they didn't know he had done anything that particular day on February 23rd, 2020. What's burglary? When without authority and with the intent to commit a theft therein, that person enters or remains within the dwelling of another. Okay. Criminal trespass. When that person knowingly and without authority enters upon the land or premises of another for an unlawful purpose. Okay, so what do you got? Kind of really similar. One's a felony, one's a misdemeanor, right? Criminal trespass, a misdemeanor. So what's really important right now is what did the defendants know on February 11th, 2020? What did they know?
Got a dumpster out by the driveway. There's some blacks right in there. Oh, is that right? Yeah. They, matter of fact, I don't come to think of it, I kept forgetting about them. They have some kids that age that hang around that house. Yeah. Well, I've been there for an actual a report of a alleged assault or whatever, and it's the kids they have are only females. Now I don't know if it's one of them's boyfriend. They only had daughters there, so it could be unless somebody's moved in with them, whatever.
Damn.
But yeah, nobody seems to know who this kid is, where he's coming from. But like he's always, all the times on the video that Mr. English sent me, he sent me one out. It's always been just in there plundering around. He hasn't seen him actually take anything. I said, so it's criminal trespassing. Yeah, very least. So loitering and
They got
prowling.
criminal trespassing, which is a misdemeanor.
On the first, right down the road. Now we did have I took a report down the road here, the house on the corner.
The bomb.
The guy where the Jeep and all is, he had some stuff stolen, some guns stolen, but we got on video the car, the people that come in and stole them. They were from another neighborhood. Yeah. How y'all doing? What's up, man? Hey,
Stole. All we got is criminal trespass.
In front of Travis McMichael, Greg McMichael specifically
Wow.
says to Officer Ash, this is criminal trespassing. A misdemeanor.
They said that. They said that. They didn't
Why
say
is it
we got a
criminal
burglary.
trespassing? He's
They
never
said we got
taken
criminal
anything.
trespass.
He's never stolen anything. Nothing had ever been taken from the construction site.
Wow.
Officer Ash says it's loitering and prowling. So
That's a
on
bomb.
February 11th, 2020 at 7:30 at night, Travis McMichael and Greg McMichael know there's absolutely no evidence that Mr. Arbery has committed any felony or theft from the construction site, from the owner himself,
And they said
from a police officer.
it. Yeah, it's hard to say you committed a burglary when
This
you're
is
out
what
there
they
saying
know
you
on
committed
February
criminal
11th.
trespass, right?
What was Officer Rash's plan? This is important. Officer Rash, Glenn County police officer, what was his plan when it came to Mr. Arbery? Was to
Damn.
get his identity information, inform him that this was private property, call Larry English in front of Ahmaud Arbery, put him on speakerphone, let the owner, Larry English, make the decision to either just ask Ahmaud not to come back or to have the police trespass him, meaning I'm giving you an official trespass warning. If you ever come back here again, you'll be arrested. This
They
was
never had a
Officer
burglary.
Rash's plan.
They never had a
Reasonable.
burglary.
This is what Larry English wanted. Just somebody tell him to not come back, please.
All the
That's
people
all.
saying they had a
That's
burglary,
all.
they never had the burglary.
That's a
They
problem.
said.
Robert
They
Rash
said
took the
they never had
stand.
the
He said a
burglary.
couple more things
That's,
that were very, very important in this case.
That's a problem.
How do
man.
you identify a burglar? He was asked by the defense this. What did he say? Caught taking something from the house. This is your Glenn County law enforcement officer Rash, who's on the case, who's been talking with Larry English constantly, knows all about this. What did he say to the
Damn.
defense? How do you identify a burglar? Because they get caught taking something from a house. Then he was asked, but wait a second, isn't burglary you enter with the intent to commit a felony or theft therein? What did he say? How would I know what his intent was?
Oops. Oops.
Right.
Boom.
Right.
Oops.
How would Officer Rash know what Ahmaud Arbery's intent was? Right there.
Oops.
Said it right in the stand.
Guilty.
But the defense, of course, says, well, there are things of value in there.
Guilty.
Okay, but those things of value have been in there. They were in there all of 2019. They were in there October, November, December, January, and February. And they were never stolen or taken. Ever. By anyone, including Mr. Arbery.
She's not Binger for sure.
It's not a burglar.
No. And she's getting better. Thank God.
Oh yeah, it's getting hot right now.
So how do you analyze this case?
Yeah, she's ending this trial.
Well, was it a citizen's arrest? You decide. But if they were not conducting a lawful citizen's arrest, you do not have to consider, you still may if you want to, but you don't really have to consider self-defense, because if it's not a lawful citizen's arrest, then they were the first unjustified aggressors and they were committing felonies against Mr. Arbery, and therefore they don't get to claim self-defense. And you can go directly to the charges in the indictment. All right, so it's not a citizen's arrest. This is the state's argument. No crime, not a burglary, not criminal trespass committed in the defendant's presence. None whatsoever. The suggestion that the victim committed a burglary in 2019, you can't arrest him now because he's not escaping from those things. Think about this. How is someone escaping from October 25th out on a dock? How is someone escaping from February 11th, 2020 on February 23rd? Okay?
That's a
That
bad
is
argument.
irrational.
I think that's a bad
Wanting
argument.
to question the victim demonstrates their uncertainty on what he had done that day, and wanting to question the victim demonstrates a lack of immediate knowledge, which is required for a lawful citizen's
That's
arrest.
true.
They didn't see him commit any crime
As soon
that
as you
day.
question
And the
them,
state's not
that's it,
saying he
because
wasn't
you
in
would have known, you would have
220,
seen it.
You know, 220 Satilla Drive. We all know he went in there and wandered around and then came out and then ran off down the street. We all know that. They didn't know that. So let's go ahead and take a look at the evidence in the case. So first off, once again, where are we? Satilla Shores, Royal Oaks is next door, Fancy Bluff, that's where Ahmaud Arbery lives. There's US 17, expressways over there 95. Ahmaud Arbery.
So you used the
Yesterday,
the fake photo.
Laura Ho got up here and she gave you Criminal Defense 101. Usually Criminal Defense 101 is no crime actually took place. Well, crime's on video. My client didn't commit the crime. Well, yeah, your client's on the video committing the crime.
Might commit a crime a little bit.
Criminal Defense 101, Step 3. It's the victim's fault. Standard stuff. Malign the victim. It's the victim's fault. I know you're not going to buy into that. It's offensive. He lived 1.8 miles away. There was his residence. There's the house under construction.
I
Only
kind of think gives the
1.8
victim
miles
fault
away.
a little bit, though.
February
I'm not too convinced
23rd,
of that. That
2020,
wasn't
Oh, you
1:08
can't say that,
p.m.
Nate.
Mr. Arbery
Just
walks
what
up to
the what the hell is he
open,
doing over here every
unsecured
night? Come on, you know.
construction site. We have our Olsen video. Remember, it's off by an hour.
I understand
and
what she's
5
trying
minutes.
to do, but I would have been like, come on, what the
Per
hell is
the
he
video
doing over
from
here
inside
every night?
220,
Really?
Mr. Arbery does not take anything, just does what he always does, wanders around and leaves. It's not a burglary. Okay. How would you know what his intent was? Well, did he steal anything? No. Did he leave? Like he always does? Yes. It's a Sunday afternoon, and Mr. Albenzi calls the non-emergency police line at 108. I said to him, why didn't you call 911? Because this was not an emergency. It wasn't an emergency. Mr. Albenzi. It's just another guy over at that house. Again, the house that's unsecured, doesn't have a fence, doesn't even have no trespassing signs on. Can you send somebody out when it's convenient? Not an emergency. Greg McMichael is in front of 230 Satilla Drive alone, and he sees Mr. Arbery running down the street. Driveway decision 1. How do we know he didn't witness any crime? But the whole thing started when I saw this guy running down the street. He does not know that Mr. Arbery was inside 220. He only sees him running down the street. Travis McMichael certainly didn't know anything. He's inside on the sofa. Greg McMichael assumed the worst. And so I thought, well, he's running from somebody. He's just done something. He might have hurt somebody or whatever, because, this guy's been in and out of that damn one house over and over and over again, got him on videos and everything. That is not sufficient for a citizen's arrest. This is not probable cause. This is, I don't know what in the world this guy was doing, but he's running down the street real fast. That's what this is.
It's reasonable
And remember,
suspicion.
he's talking to the
It's not
police
probable
about what
cause.
he believed Ahmaud Arbery had done that day. He must have done something today. He's running down the street. Let's chase after him with guns. That's what happened. driveway decision. Greg McMichael chooses to arm himself with a handgun. Travis McMichael chooses to arm himself with a pump shotgun. These are their choices. Travis McMichael had his cell phone, but Greg McMichael does not take his cell phone to him. All right. This is really important, ladies and gentlemen. On February 11th, the 911 operator stayed on the phone with Travis McMichael the entire time, right? So if Greg McMichael had actually made contact with the 911 operator, what would have been happening inside the truck? He'd have been on the phone with that 911 operator going, yeah, he's going this way, he's going this way, he's going that way, okay? The fact that Greg McMichael was not on the phone with 911 giving them a play-by-play tells you that Travis and Greg knew they had not called 911. Travis knew his dad hadn't called 911, okay? Neither one of them called 911.
I hate these inference
They
arguments.
had no intention of calling 911.
I think
Just
she
like
has
they
better
went and
arguments. I
confronted
think
the
she's.
homeless guy in the
I
bridge
understand where she's
and then
going,
called
but I think she has better
Just like
arguments.
they
This
ran
is
back down on February
She's
11th,
not-
hammering the wrong point.
2020 to the house.
Yeah, she's
and
not
then
been.
called
She's
911.
not as good as she's been throughout the
What do
trial,
they
where
do?
she's
They
been
get their
absolutely
guns, they
deadly
go to do a
at
confrontation,
points in this
and
trial.
then they call 911.
Yeah.
Greg McMichael didn't
She's
even
gotten
bother
better
to
than
take
since
his
she
cell
started.
phone with
It's
him.
not. It's not
Obvious
great.
to
It's not
Travis he
bad.
Did not call 911.
It's like a
Travis
6.
McMichael. 60
Oh, cool.
seconds
Not
after
bad.
Mr. Arbery has
Maybe a
run
little
past
bit
two
I'm just saying what the
Scintilla
I'm
Drive,
just saying what the
he
court
makes his
says. But yeah,
driveway
he can
decision.
definitely come on.
Doesn't tell his dad to calm down. Doesn't tell his dad that no, he's not getting a
We
shotgun
disagreed
and run
about
after somebody.
Chauvin too.
Doesn't tell his
You
dad
said it
this
was
is
going
a
to be not
really, really
guilty.
bad
I
idea.
said it was
We
going to be
shouldn't do
guilty.
this. No, what does he do?
You disagree?
His white F-150 pickup truck backs out of the driveway and heads in the direction that Mr. Arbery was running.
I thought. I don't know why he said
This
that.
happens
I mean, I thought for
after
sure.
He gets
I
his
mean, that was
shotgun
even
and
clearer
getting
than
into his
this
pickup
in the
truck.
Chauvin trial, in
Travis
my view.
McMichael testified that he went to the end of the driveway and he saw Mr. Albenze point
Your
one
only,
time
your only
down
hope
the
there is
street.
to say that
There was no
the
verbal communication by Mr.
Chauvin isn't a
Albenze
causal
with the
factor, and
McMichaels.
good luck with that. Jesus
Yeah.
Lord.
That was a lie.
I like the way she did that. That was a lie.
I'm going to focus your attention up here, ladies and gentlemen. What we have here is 21325. Can y'all see this okay? Am I blocking your way? All right. So what we have here, as you can see, is Mr. Albenze, right? Here's the black car. Remember the black car goes by, then Mr. Arbery runs the other way, down this way, right? So let's go ahead and play it. There goes the black car. Mr. Albenze's there. There goes Ahmaud. Do you see him? Right there. Ahmaud's running, running. There he goes, right there. You see him? Down the street, and there he goes. All right. Then what happens? See the white truck right here? You're looking at it? Somebody comes out, goes to the door of the truck. Mr. Albenze is still right here underneath the tree. Somebody else comes out. Do you see the second person come out and go around the front of the truck? Greg McMichael. Because where's Greg McMichael? Greg McMichael's going into that, sit in that car seat, right? Second person comes around. Then what happens? Then Mr. Albenze walks down the street. He's walking, he's walking, he's walking, he's walking. Truck pulls out. Wow. Truck pulls out. Mr. Albenze does his pointing when the truck is already pulled out and going down the street. Want to see it again? Back it up. Here we go. There's Mr. Albenze. Here's the black car. There goes
You
Ahmaud.
got about 40 minutes left.
Running down the street. There he goes. This is the white truck. He's still underneath here. There comes somebody in the truck. He's right there. There comes Gregory Weigel. He comes around. He gets in. Then Mr. Albenze starts walking down the street. Truck pulls out. There goes his arm. There goes his arm. Where's the truck? Already pulled out. Already pulled out and heading down the street. All right. Should you trust the statements of Travis McMichael? Well, let's go ahead first take a look at this.
They love this clip, this this board thing in Georgia.
He told you he's not going to chase or investigate someone who is armed.
I like it.
And yet all
like
he
it.
talked about was, well, he kept reaching in his pants. He kept reaching in his pocket.
I prefer it to
Well,
PowerPoint. I'll tell you
did you think
that.
he was armed or not? Then what did he tell you?
Okay,
This is
that's
what I
really
was
hard to
thinking.
read.
Mr. Arbery may have run by. Maybe Matt had seen him. Maybe he has broken in. Maybe Larry English is over at 220. I don't know. Maybe Ahmaud Arbery was caught. Maybe Ahmaud Arbery is running from the police. These are all maybes. He doesn't know anything. These are all the maybes he testified to. He said he assumed he was committing a crime. That's what he said on the stand. Remember, I wrote it out. You said you assumed he was committing a crime.
Yeah, he convicted
I went
himself.
down there to see if it was him. Then he said, I don't know.
Don't talk to the police,
I don't know
people.
what he did that day. I don't
Don't
know.
talk to the police. It will not
Yeah.
end well.
Then he wanted to talk about his totality of the circumstances and all that stuff that he knew that was going to
He's
allow him to
convicted
do the
himself.
citizen's arrest. What did he talk about? Well, I heard from my mom about the stuff stolen
Yeah,
off
this
the
is going
boat.
to the jury today.
Okay, well, can't arrest somebody on the unsupported gossip of someone else. Can't do that. And then, I saw him inside the house, and I knew he was in there on a couple other days because I'd seen video on February, on February 11th, he saw these videos. Okay, well, that's not having committed a crime in his immediate presence. This is somebody showing you some stuff later. And then he knew about the white couple. Oh yeah, I knew there were other suspects for stealing the stuff and other suspects who had gone in the house, the white couple. Okay. And then he also said, well, yeah, and then there was the shady looking guy under the bridge. He was also kind of a suspect. He said, I want to talk to you. I want to talk to you. What happened down the road? I was ordering him to stop. What gives you the right to order Ahmaud Arbery to stop? My impression was that he could be a threat because who knows what can happen. Oh my God. Self-defense, you have to think you're in imminent danger of receiving serious bodily harm or death. It's imminently happening. I'm about to die. My impression was that he could be a threat. Yeah, who knows what could happen. You guys understand?
Oops. That doesn't sound like self-defense to me.
Yeah,
it
that's
doesn't.
that sounds like he gave it up right
A
away.
little speculative there.
Yeah.
All right, so what else have we got? If Greg had called 911, he still would have been on the phone with 911. We know that. That's how 911 works. They stay on the phone with you. He knew he wasn't on the phone with 911.
I might have
He
been
told
a
you he
7
didn't know what his
or an
father
8
was
with
saying
this.
to Ahmaud.
Yeah,
Really.
and they don't need this at this
That he
point, so
was
they're
in the car
weakening
with
their
his
own
dad,
argument.
But he has no idea what it was that
Well,
his father
they're
was
giving
actually
weaker
saying to
arguments
Ahmaud,
that could
as
be
well as what
attacked.
he was saying. Now, what did he talk about? He talked about that continuum of the use of force and blah, blah, blah. Level 2 is commands. Okay. I'm sorry. How do police officers command people to do stuff? How do they usually do that?
Loudly?
Police officers, are they yelling at you? Or are they politely saying stuff to you when they're commanding you to do things?
That
Do you believe
depends.
for a minute
Sometimes
Depends
the
on where
police
you
talk
are,
softly
what
to Ahmaud
officer
Arbery?
sometimes
you're
police
with.
are place.
What's going
Definitely
on? What are you
depends on the
doing?
situation.
Please stop for me. Do you really believe that?
I
for
really
1
don't
minute?
like this
I'm gonna ask
argument
you
either
another
because
question.
she doesn't know
Do
the
you
individual
think
experiences of
this
the
Travis
jurors. If there's a
McMichael
juror,
Texas
there's like,
man
oh, I've met a cop
was
who's,
the
you
same
know,
Travis McMichael from
And
February
she has
23rd?
she has so much of
You
a
think
better
they're the same
argument.
person?
Their
Yeah.
argument is we're arresting him for
Or you
burglary
think this
because
is
of some
trial
stuff that he did on
preparation?
February 11th.
well, you
Ballgame.
make a bad
Ballgame.
argument like
What
this,
tone of
and then
voice
they're
do
going to
we have
focus on
being
that and
used
say,
by
oh, let's not look
McMichael?
at her rock solid arguments. Let's look at the tiny ones where she said something.
Hello.
Can't really,
911 was the address emergency. I'm out here at Satilla Shores. There's a black male running down the street. Where at Satilla Shores? I don't know what street we're on. Stop right there! Is it? Stop! Travis! Sir, hello?
Ask yourself, was that the tone of voice being used? Well, yes, we know it was. He just said, stop. God damn it, stop, to Mr. Arbery in that tone of voice. All right, use of force continuum. Presence.
Whose
Did
point
not
was she just
have-
making?
No badge, no
I
uniform,
don't
no
know.
authority. Just some strange guys in a white pickup truck. Strangers. Verbal commands. They don't have any authority to use verbal commands.
I think she's just arguing what they couldn't even
This
say
is a
themselves.
fellow citizen.
That's true. You don't have
He's
that
another
authority.
human being.
Verbal commands, fellow citizens.
They're
You
pulling up
can,
on him and they're commanding
but they,
that he stop and talk
but they
to
don't
them.
have to stop though.
And then, of course, he skipped level 3, level 4, level 5, and went right to deadly force. Boom. Someone's dead. Claims he didn't cut off Ahmaud on Burford, did not get out with his shotgun. I don't know, you believe any of that? Told the police he got out of his car in Holmes, a few houses down, and yelled at Ahmaud to stop. Now he says that didn't happen. And his convenient excuses, I was really confused. What did he say the Coast Guard goals were? To not escalate, but to keep everyone calm and cool. You don't want anything to escalate. But then he tells you, oh, but you pull out a shotgun and point it at somebody to de-escalate a situation.
Yeah, that was a nice
What are you
moment.
talking about? Does this logic make any sense to anybody?
It does not. No, I have to agree with that.
Travis
No.
McMichael never said to the police, I was making an arrest. I was trying to arrest him for the crime of this. Wouldn't that be really, really important?
Shotgun
Hey, I was trying to
de-escalation.
effectuate a citizen's
Yeah,
arrest
shotgun
for this
de-escalation.
crime
That's a new
that I
one.
know he committed. Wouldn't that be something you'd tell the police? Never once. Never told Mr. Arbery he was under arrest. Never said, I saw him commit the crime of blank today. Because he didn't. He was sitting on his sofa.
Tell you what, next
Never
time I see a
said,
bar
I was
fight,
afraid he was
I'm
going to
gonna
hurt
whip
my
out a
dad.
shotgun.
Calm down. Never
that should
even
calm
mentioned
everything
being
right down.
afraid for his dad.
We'll be all
Not
good.
once.
Yeah. Especially
Anything
in Texas.
about
Try
the
that.
English's
Try that
vote or
anywhere
anything being
south
stolen
of,
from 220.
try it,
Never
or in an
mentioned
open
it.
carry state.
Never talked about it. 2 hour and 45-minute
But
interview.
people will be happy
doesn't
because I'm
talk about
de-escalating.
any of
Remember?
this stuff. Assume
Remember?
the worst.
Oh, and you could go around and be a
Here's what he
professional
did.
de-escalate. Just go from bar to bar.
So
and
he
to-
stopped.
to
And
Oh,
I
yeah,
said,
no.
"Look, just want to talk to you, where are you running from? Where are you going?" This is what he says he said.
De-escalator.
He's asking Ahmaud about what he was doing that day.
And if
That
a
day.
shotgun is de-escalated,
Because he didn't know
think
Reminds
about
me
what
of-
happens. I
that
could use
day.
that be even more
So you assume the
de-escalating.
worst, you must have
Well, it
committed
reminds me
some
of
crime.
Grosswitz, whether he was
What's your
when
emergency?
he was saying, "Oh well,
Yeah.
I'm
Is
peaceful.
it
I would
black
never
man
use the
running down
gun.
the
I would
street?
never." It's like, okay, so then you pull out your Glock. And he's like, "Yeah, but I'm peaceful.
What did
It's,
Agent
it's his
Seacrest
Glock
tell
of
you?
peace." You know, it's his,
GBI agent. I can't
Yeah,
compel
that's a little
anyone
hard
to
believe.
speak
I'd
to
never
me.
shoot anybody. Okay, let me get this straight. You have a concealed
They
carry
knew
permit,
better.
You have a loaded
Just like
firearm.
Agent
You
Seacrest
pulled a loaded
knows. I
firearm.
can't compel anybody
And
to
you're
talk to
extending
me.
his direction, but you never shoot anybody because it's against your
All right,
morals.
let's go ahead and talk about Defendant Brian.
Not buying that one, man.
did he have an extended
307
magazine
Burford.
too? If I recall.
You've seen his night
I
out
don't
here,
remember.
not
I'm not
playing
sure it
for you
matters
again.
much either way.
Motion
No.
activated on the porch.
Probably not so
Travis
much.
Michael's white 150 pickup truck comes in front. Driveway decision. And this is important,
The
ladies and
Glock
gentlemen.
40 caliber of
This is
peace.
really important.
Well, if you want
Y'all got 'em?
peace though, it's only the 9mm. And though the people who are gun people in the room
Why is this
hopefully
important?
had a
What does
small
this
chuckle
say?
to themselves when I said that.
Mr. Brian.
Well, and the Glock. Keep
from
in mind, the
this court
Glock is
can
it
tell
won't
that
de-escalate.
they are
It's just a Glock
chasing
of peace. To
and
professionally
trying
de-escalate, you
to
need the shotgun.
falsely imprison, stop, define, confine Mr. Arbery.
So
He can tell it
that's
from
why you
his
watch the
porch.
show, is to learn.
He
what
knows
to
exactly what
de-escalate
they're
and
doing.
Just
Y'all
are
got 'em?
peaceful.
He knows what they're doing, and you know what he chooses to do? His independent own decision. I'm going to go join him. to try and stop this guy, confine and detain him. He just joins in and starts helping. His driveway decision.
This is the best the volume's
That's
going to
what
get for
being
this.
a party to the crime is. You go to help some people who are committing some crimes, trying to stop this guy and detain him and
It's a good
confine him.
question.
He joined in. Y'all got him? He knew exactly what the McMichaels were doing. What did Mr. Bryan tell you? So I just kind of sat there for a minute and didn't really know what to do. And then he was trucking. So, I mean, he closed in on me quick. And as soon as he got up to me, I overshot the road.
No, this is it.
I was
State
kinda
speaks first and
angled.
last.
I overshot the road and forced him to go down into the ditch right there. Aggravated assault with a pickup truck on Mr. Bryan's verdict form? Check. And I angled my truck at him again. I think he kind of turned around. I missed him or whatever. I missed him.
This is the truck of
He was
detaining
intending to hit
we're
him.
talking about now.
I missed him. I mean, when you say, well, I missed him, what does that mean you were trying to do? You were trying to hit this person. Then at the scene, he tells Officer Minshew, one time when I cornered him up over here on Burford, he was trying to get in my truck. He tried to get in my door. Okay. Trying to get in his door. Or, Mr. Bryan, did you get so close to Mr. Arbery that Mr. Arbery had to push off from your truck, getting white fibers from his t-shirt and his palm print on your truck? Because you got so close to hitting him, he had to push off to get away from you. I mean, I can't say for sure that he wasn't on the door. I didn't give him a chance to get to the door.
11-1.
But after I angled him off the side of the road,
11 white
and I
drawers, one
kind
black
of went
drawer.
on past him because I didn't hit him. Wish I would have. Might have took him out and not got him shot. But I probably got past him a little bit. And he comes up on me, and I could see him in my mirror, and he was coming to the door, and I see his hands right behind the door. After I angled him off the side of the road, I kind of went on past him. I didn't give him a chance to get to the door. Yeah, towards the entrance. But I confronted him again. I angled at him again. We're now at aggravated assault number 3. Before we got to the road he was lying on, right at that house that's on the left-hand side, you're heading towards the entrance of the neighborhood. So he confronted him once again, right there at that corner of Holmes and Satilla. I was fixing. I put it in reverse and was going to back up at him. And that's when he made his move to go down the road it happened on. Felony murder, right here. Felony murder for criminal attempt at false imprisonment. Felony murder for aggravated assault with a pickup truck. Mr. Bryan kept Mr. Arbery from running down Satilla Drive and out of Satilla Shores. He redirected him up Holmes. But for those actions,
less is more.
Mr. Arbery would be alive. Played a
I think
necessary and
I think she has
substantial
better
part
arguments. I
in the
think
death
she's.
of
I understand
Mr.
what she's
Arbery.
doing.
Yeah.
Well, do you think
But-
she's
All
just
right,
trying
so I
to
backed up
touch
and
all the
started
bases,
going down
like
that
clean
way.
up
I think I
all of
angled
the
at him
little,
again.
just the idea I don't
Yeah.
want to leave any little.
Kind of forced him off the road or something
I
right
don't think
in
you have to be
here.
afraid of
And
some.
he turned around. He turned around right here.
Oh,
The
is
black
that more
guy did. He
self-defense in
turned
here?
around maybe down this far, so he turned
They
around,
sent him the
started running
link.
back the other way.
Oh,
And I
yeah,
pulled
in the
into
chat.
a
You can
drive or
definitely come in.
something and started to turn around.
He's more than welcome.
4th aggravated assault with a pickup truck. There's his route. There's the McMichael route. And here it is all together. So once again, ladies and gentlemen, the indictment. How in the world could Defendant Bryan be held responsible if he was in his Silverado filming the murder at the time Travis McMichael murdered Ahmaud Arbery? How can Greg McMichael be held responsible? Okay, it's real simple. Party to a crime. The law does, in Georgia, believe that everybody who helped, encouraged, advised,
Hand to one, hand to all, baby.
went inside a house and grabbed their son and told him to get a shotgun and come on, they're all equally responsible
Don't
for
enter
the
conspiracies or
ultimate death
assist in crimes.
of the victim. Because a person is a party to a crime only if that person directly commits the crime. Travis McMichael, pulling the trigger on the shotgun, helps in the commission of the crime. He wouldn't have been able to do that if not for his father and if not for Mr. Bryan. Intentionally advises, encourages. That's what Greg McMichael's doing. Cut him off, cut him off. Go this way. No, I'm going to go that way. What are they doing in the truck? They're working together, Greg and Travis McMichael. That's why they're both responsible. Laura Hope got up here and said, Greg McMichael's not a murderer. Yes, he is. Greg McMichael is just as big a murderer as Travis McMichael is because he's a party to this crime. okay?
Yeah, I'm feeling you,
When three
Alice.
people chase an unarmed
she's-
man in two
she's
pickup
lost
trucks
me.
with guns in order to
I was
violate his
excited this
personal
morning.
liberty.
She hasn't quite
Listen,
lost me,
I'm not
but it's
really
definitely not
responsible for
sharp
that.
as it,
Under
she's
the law
has
in
been.
Georgia, no one gets to say that. Everybody is responsible. All right, how?
If I was a juror,
All right,
I
I'm
would
gonna
be
give you an
coming in
example. This is just
guilty.
an illustration.
I'm coming
Just to
in like,
make a point,
ah,
okay?
we might have to talk about
Four
this.
men drive to a bank to commit
Even
an
though I
armed
still
robbery.
think,
Maybe.
based on the law, they're
Alright.
guilty. But
You
still,
got the
now
driver
I'm
who never
like,
gets out of the car. You got
you
the
know, it's
lookout
not
who stands
clear.
outside. You got a guy who goes in without a gun, and you got a guy who goes in.
So how much are they
the
going to be
bank
asking
and
to?
shoots the guard.
He didn't know that they were.
hold on.
committing-
So who's guilty?
Let me hear this.
Under the law in Georgia, all of them are responsible.
Okay,
for
sorry. Go ahead.
aggravated
What's
assault
your
for
point?
shooting
I
the
just wanna see
guard
Well, no,
what-
if he gets in the truck and he doesn't
or
know
trying
that
to
they're
rob a
going
bank
to
or
commit a
robbing a
crime,
bank,
doesn't
all right?
know,
Because
all the facts of it.
They committed the crime,
You've
or
got to
they
be
helped
asking
in the
yourself
commission
how
of the crime,
responsible is
or they advised and
really?
encouraged someone to
Is he
commit the crime.
just as guilty as someone who pulled the trigger?
And of course you're saying, but Linda, only one
If you
person
conclude
had their
that
finger
he's
on the
part,
trigger in
if he's
this
party
case.
to the
That was
crime,
Travis
then yeah.
McMichael. So how do we find Greg McMichael
I'll
and Willie
give you an
Body
example of
Bryant
that
guilty of
after
malice
she
murder?
finishes.
Well, under the law in Georgia, it's as if they were all holding the gun together. And in this example, the guy who never got out of the car, who was the getaway driver, is just as guilty. In this example, the guy who got out of the car and just stood at the front of the bank is just as guilty. Party to a crime. So under the law, all are involved.
Different
Why?
states.
Well, Greg McMichael, he was seeking.
I was Wisconsin.
Is this
Georgia.
really different in
At its
other
at its
states?
He
closing.
was encouraging Travis
Closing.
McMichael
Yeah.
to come with him, encouraging Travis to cut him off. Greg McMichael threatened Ahmaud to get him to stop. Okay? We would not be here if it weren't for Greg McMichael. Travis McMichael. Without Travis McMichael deciding to actually take his shotgun and help his dad. He could have told his dad, we're not doing this. Calm down. Call the police. There's a whole bunch of decisions both of them could have made that would never have resulted in Ahmaud Arbery's death. He decided he was going to drive his pickup truck to chase Ahmaud, and he got out of that truck with that shotgun, totally and absolutely unnecessarily. Mr. Bryan, who decided to help the McMichaels, without Bryan, who then assaulted Ahmaud.
He may be
in
right
his
today.
pickup truck
He may be
in
right.
an effort
He
to
may be
falsely
right.
imprison him on Burford,
He's saying they're not
without him
guilty.
redirecting Ahmaud
He
onto
may be
Holmes,
right.
without Bryan chasing Ahmaud toward Travis McMichael, we wouldn't be here. Because Ahmaud Arbery would not be dead.
Yeah, I agree.
Doesn't matter who actually pulled the trigger. Under the law, they're all guilty, even of malice murder. All right, let's take a look at the crime scene. Of note, Ahmaud Arbery had nothing on him, no bag, no backpack, no burglary, no cell phone, no ID, no wallet, no keys, no gun, no weapon, nothing. I'm going to show you some crime scene photos. So what do we have? All right, take a look at this. This is what's important in this picture. These pants are so baggy.
Oh, thank you,
Look
Jen.
how
I
baggy
appreciate
they are.
that.
Look where his
Thank you.
belt is. He's running like this. There's no way they believe he had a gun on him. Absolutely no way.
Yes.
Mr. Arbery was shot. First in the torso and through the wrist. All right? He was shot this way, where it came out this way. So what's he doing? He's coming around that corner. Here it is. Here it is. His wrist gets shot. There's no way he's striking Travis McMichael. There's no way he's hitting him. All right, we don't know. Did he grab the end of the shotgun? Did he try and push it away? Who knows? What we do know
I think it's a
is it
mistake
happened like
if she
this,
doesn't say those
and Travis
words.
McMichael fired.
They've conceded that this
They
didn't
struggle
happen
over
in
the
their
gun.
presence.
Yeah, then
Blah
they're
blah
struggling
blah.
over
Right?
the gun.
Showing where
Two
they
more
conceded to
gunshots,
that,
and he gets shot.
and the
Yep.
law says they have
I'm
to
gonna show
concede
you
it
the
in their
crime scene photos.
presence. And sit
So
Yeah.
what
down,
do we
right?
have? Why do we know he got shot in the
That's she
wrist?
has to say those two
Because of
things.
the
If she doesn't say
blood
those two things,
spatter. The arterial
it's a toss-up.
spurt.
If she
Well,
says
then
those
just-
I
two
don't know if it's
things,
quite a toss-up.
Okay.
It is
Well,
a
just
Why
toss-up.
is there blood here in the road?
It's
in the
if
driveway?
it doesn't
The
fit, you must
arterial
acquit, right?
spurt
Just
from the wrist.
keep
That's how we know
That's
the
it.
wrist
hitting
got
the
shot
one
when he was
point.
shot in the
Yeah.
torso. And there's the evidence of it.
she
in the
she
crime
has
scene photos.
she has the she
What
has
do we
the
also
killer
know?
point.
Here's the
Storytelling,
gunshot wound
baby.
in the torso.
Storytelling.
It's great,
Here's
but
the
you
gunshot
got to
wound
know
under
when
the
you
armpit.
got to know when you got the
Both
she got the
lethal-
bomb.
Lethal injuries.
This is what I mean. She's been
Travis
professional up
McMichael,
till
at the
now,
end
but
of
this is
his
what kind of
interview,
more amateur
the
people
very
do,
end of
right?
his
Which is
interview
they
with
feel like they
Detective
have to
Hill-Hilly.
clean up everything
Do
that
you
the other
remember
side
he
said.
grabbed
And
the
it's like,
shotgun at
yeah,
all?
if it's
I want to say he did,
just
but I honestly
give him
cannot
time
remember.
on the dumb stuff.
Yeah, I think 20, 30 minutes would have been much better
If
here.
he grabbed that shotgun,
Yeah.
that would be the first thing Travis McMichael would have said. Yeah, he grabbed my shotgun. All right, we are going to talk about Greg McMichael. Greg McMichael did attempt to control the narrative after this took place. He's the one who
15
started
minutes,
this whole
15,
thing,
20
and now
minutes
his
left?
son has killed someone.
Well, just because
And
you
the-
have the
that young
time
man
doesn't
is
mean you
laying
have to
dead
use
in
it.
the street from being shot by gunshots.
That's very
So what
true.
does Greg McMichael do?
That's
Well,
tough for
while
lawyers
first responders
to
are on the
not use
scene,
all the time.
he's
but
going up and
yeah.
he's telling his kid, "You didn't have any choice."
It's
He goes
really
over and talks to
baller
Brian to
when they
find out
don't.
what he
I've
saw.
seen it done at
Oh,
the
he's
U.S.
got a
Supreme
video.
Court where
He
they're
goes over
like
and
they
he
only
talks
get a
to the
half hour
press. He's outside the
Supreme
crime
Court.
scene tape,
And I've seen people
wandering around talking
stop
to people.
before
Someone brings
30
him
minutes
his
is
phone.
up. It's pretty
A
baller when
stranger
they can pull
comes
it
up
off.
to him. Some stranger,
Yeah.
some neighbor comes up to him. I mean, this is a crime scene. There is a deceased young man in the middle of the road, and strangers are walking up to him. And what does he tell this stranger?
Listen,
This guy
I've
ain't no
given this woman a
shuffler.
lot of praise,
This
but if
guy's
she
an
doesn't connect
asshole.
those two things at the end, if they've conceded the point, they've screamed they've conceded the point,
Malice,
then
right there.
she's overselling.
That's how
Yeah,
you know.
yeah, she's
right there.
overselling.
Oh, yeah, selling
agree,
past
Drew.
the close. Selling past the close.
Yeah.
is the other thing that
2:15
I'd like
p.m.
to
He's
see.
talking to
There's that
Captain
too.
Tom
You're
Jump,
right.
the head of CID,
Selling past the close.
the head of the Criminal Investigations Division of Glenn County Police Department, while Tom Jump's crime scene tech is taking photos. Okay? And then Greg McMichael drives his white truck from the scene. Sheila Ramos never got any pictures of the white truck. Sheila Ramos never got any pictures of the Silverado. The white truck was never searched. Mr. Bryan's truck was never searched. Neither of those trucks were impounded.
Yeah,
So what do we got?
she's got 21, and she's
We got
telling him,
this.
"Give me a hit."
Outside the crime scene tape, talking to the head of CID. And what happens is, look at the crime scene photos. Take a look at them. What happens next? He
Just
drives that
using
truck
the
away.
analogies. What is it when you're in
Wow, the
football?
crime
You're
scene tape
7
is there
points up,
taking photos.
2 minutes on the
Yeah.
clock. What do? You protect the lead. You protect the lead. That's
Yeah,
it.
exactly. Yeah, the problem here is it's a recitation of
No one
facts.
said Mr. Arbery had a
without the
weapon.
connecting story.
Nobody said Mr. Arbery made any verbal threats or gestures.
It's
Nobody
not as
said I saw him
muddled
commit
though
a
as
crime
some of
today.
this I've seen.
No one said I'm making a citizen's
it's
arrest.
not
No one was
organized.
trying to arrest him for the crime of anything. No one ever said any of these things on February 23rd, 2020.
Yeah, maybe
Agreed.
Greg McMichael's
This is a
statements
very
to the
good
police.
point.
These are
Yes.
important. This is why Greg
I think
McMichael
you're right.
maybe
I think
maybe
she's
she
going for the
overreached
Did this
with the
guy
mouse
break
murder.
into a house
Overreach
today?
can kill you as a
That's
prosecutor.
just it. I don't know.
You know,
That's what I told what's her name out there. I said, listen, you might want to go
Yeah,
knock on
I'm with you,
doors
Drew.
down there
Drew,
because
she's
this guy
lost me.
just done something because he was fleeing from.
I'm gone.
I don't
not
know.
listening anymore.
He
Like,
might have
if I'm
gone
a
in
juror.
somebody's house. You can't make a citizen's arrest because someone's running down the street and you have no idea what crime they have committed that day. You can't
This is
hold
where she
somebody
should
so the
end
police
up.
can show up to go, well, he must have done something. Why don't you police officers go
Yeah, if she
figure out
lands
what
it
it
here,
was that
she-
he went and did
cover
today?
it.
Yes,
But
this is
that's
the
what
landing.
Greg McMichael told the police. Then he was asked, is he picking up anything or going through anything? You know, not that I recall. I don't think the guy has actually stolen anything out of there.
That kills your
Or
burglary.
if he did,
So-
it was
so
early
she's
on in the
killed
process.
the burglary now.
But he keeps going back over there over and over again. This
I don't
damn
think he's
house.
actually stolen something. So that kills the burglary.
No one ever said, we have evidence that he stole items out of Larry English's boat back on some unknown date. So we were trying to arrest him for that. There's never any mention of Larry English's house.
Yeah, she's
And
rambling
stolen
about
items
shit
off
that
the
she's
boat.
already said before.
Not by anybody. My intention was to stop this guy so they could be arrested. Never says for what. Never says what crime it was he was going to be arrested for. I don't think the guy's actually stolen anything. Did he break into a house today? I don't know. And in that same sentence, he could be arrested or at least identified. So this is all for identification. This
she
whole
did that
entire
already, though.
thing, this was all to do what? Identify Mr. Arbery. That's what we're doing.
Not
That's what
conduct a
Greg
citizen's
Michael says.
arrest.
How do you know it was an attack on Mr. Arbery? Strangers with intent to kill. I yelled, stop or I'll blow your fucking head off or something. I wanted to know that we weren't playing. This is what he said to the police. Now, Borho got up here and went, yeah, he was just confused. He didn't mean that. He didn't remember what he said. Really? He proudly told the police, this is what he said to Mr. Arbery. We're going to kill you if you don't stop. Greg McMichael. Yeah, He was trapped like a rat. Knowledge, intent that they had committed false imprisonment
Good
on
point.
Holmes Drive. Right there. Greg McMichael, guilty of all charges. Why? What's your emergency? I'm out here in Satilla Shores and there's a black man running down the street.
Hmm.
Yeah, this is what we get. This is what we get. Driveway decisions and assumptions. Right here.
Yeah. Good point.
Yep.
We've gone through
This
all
is
this. I'm not going to
because-
do it again.
She's got to hit all three
Bottom line, ladies and gentlemen,
defense
they
attorneys.
committed 4 felonies against Ahmaud Arbery.
I think she's
in
But she
violation
already
of his
hit them.
personal
She's
liberty
supposed to
already
be.
hit him.
before he
She's already hit
finally
them in the first. She
tried to
closes
run around
already.
their truck.
This is
after
rebuttal. So she
running
already hit all the
from
points she needs to
them
hit.
for 5 minutes.
Now she's essentially closing
Trying to
again,
get away
but
from these
this is supposed to be
strangers
rebuttal, and I think she just has
who are
to
yelling
strong the
at her.
rebuttal.
Yelling at him, threatening to
She's
kill
trying to
him.
get to the emotional. I understand what she's doing, but she's got the win already, right? This is to me. This is how you muddy the win. You know,
And then they killed him.
I was at 80-20. Now I'm kind of like 60-40.
Well, what do you really
Do
mean?
you
Like
have
that's how
any
you are,
doubt
just like
that
in
they
terms of
committed
attention
all of
span?
the
'Cause
charges
I
in the
think
indictment?
No,
My
in
hope is-
terms of
No.
how clear it was. It's clear to
Oh,
me
yeah,
because
yeah.
I'm a lawyer and I know. But if I'm just looking at this as a regular person,
Remember, a reasonable doubt does not mean a vague or arbitrary doubt. It's a
what?
doubt for which a reason can be given. In other words, you say it out loud.
I don't think she's made it very
I
clear
doubt
enough. This was
William
their
Roddy
argument.
Ryan
This is the
was
law.
committing aggravated assault
Ball game.
with his pickup
That's where you
truck
go with this.
because it was just reckless conduct. If you can honestly look each other in the eye and say that about Mr. Bryan with a straight face, ladies and gentlemen, you're the jury. You decide. This is your search for the truth. If you honestly can look at each other and say that out loud, then find him not guilty of the aggravated assault. Find him guilty of a lesser. Because you decide. You are Glenn County. I mean, today you are Glenn County.
Hmm.
Remember, this isn't about having personal baggage back in the jury room. It's not about a point of view or an agenda or anything like that. That's not what's going on. Y'all are really, really smart and you've paid really, really close attention to this case. You're going to determine what
Tease
really
up the
happened
jury
based on
now.
the evidence, and then you're going to apply the law that the judge gives you
Whether
to
it's
that
intended
evidence.
to or not, it feels
It's
like
not
it's
about being an
pandering.
advocate for anybody.
If I'm in the jury, I'm like,
It's your search for the truth.
don't kiss up to me.
I suggest once again that you work from the bottom of the indictment. It's just going to be easier.
That's it. You're going to sit down
Criminal
now?
attempted false imprisonment, and then work your way through it. It'll help you logically. Remember party to a crime when you're talking about Greg McMichael and Mr. Bryan. You're going to get a verdict form. The state is asking you to fill it out this way, especially for Mr. Bryan and the aggravated assault with the pickup trucks. He's not guilty of simple assault. He's not guilty of reckless conduct. He's not guilty of reckless driving. He's guilty of aggravated assault for putting Ahmaud Arbery in
I'm saying
reasonable
this is
apprehension,
like her second closing
fear
of the
of
rebuttal.
receiving
That's what I'm
serious
saying.
bodily injury.
Aggravated assault, I think you've
I
got for
overshot the
sure.
road and forced him into
Yeah,
a
you got
ditch.
aggravated assault. The pointing a shotgun at him running down the street, that's aggravated assault.
Ladies
I
and
don't think we
gentlemen,
can get over that.
Here's the thing. This isn't about whether these 3 men are good people or bad people. That's not what this is about. It's about responsibility. It's about holding people accountable and responsible for their actions. When they do something like this, they have to be held accountable and responsible. Nobody gets a free pass. Okay? Would you get a free pass? Who gets a free pass? No, the law basically says if you commit the crime, you're going to be held responsible. And ladies and gentlemen, when you come back with a guilty verdict on all the charges, this isn't saying somebody's a good person or a bad person. What you're saying is, you know you committed the crime. Now we know you committed the crime too. That's all it is. They know what they did. It's not like they don't know what they did. They know exactly what they did and they know why they did it. It's not a mystery to them. When you come back with your guilty verdict, all you're doing is telling them, we know what you did too. And we're going to hold you responsible for it. Because guess what you did? You turned this young man into that young man. That's what you did. For acts absolutely no good reason at all. Ladies and gentlemen, I'm asking you to find all 3 defendants guilty of all the charges in the indictment. Thank you very much.
It's like a 4 to 5.
All right.
Yeah,
Excuse me,
I'm
ladies
at
and gentlemen,
maybe
we're going to take a
6.
10-minute recess, and then we're going to come back with the charge of the court. Do not begin your discussions or deliberations in this case until you have received the final charge of the court. Again, with about 10 minutes, and we'll come back and get that
That's true.
onto the record. Thank you.
All right, for sure.
Yeah, I'm that you had so much time. That could have been so much better.
Yeah.
I think she still got enough to get over the line, but she
Yep.
just made it harder for herself. Like I could have, I think that she could have closed this out where you had a verdict today.
Yeah. She's been so sharp throughout the trial. I think some of the criticism is based on how sharp she's been throughout the trial
That's
overall,
true.
where
Take
she's
10-minute
been
recess.
very, very good.
20 to 11 will reconvene. Thank you.
And here the theming was, there wasn't really a coherent theming. It was a recitation of facts. I think it was unorganized, and some stuff was just muddled, and you lost the point a little. It was too long. It was way too long. That's one of the major problems. It should have been a half hour, not 2 hours.
It's you already had the entree with that whole with the first part, right? That should have been your 2-hour entree, and then your meal, and now you're talking about the dessert, and that's kind of how I think about rebuttal. Rebuttal's the dessert, and the dessert here was, hey, here's what they said, here's what the law says. There's really no argument, right? We really don't have any contention here about this whole citizen's arrest thing, right? And I would have ended on that, pretty much that note. The defendant said that they didn't happen in their presence, and guess what? That's required, and it keeps it simple for a jury. And I understand she wants to get this emotional thing. She wants to try to make it seem like we have all this, but it's just like you lose everybody, and I think she lost me. I'm just I know uncivil. You said she didn't lose you, but she lost me. I don't
No, I appreciate
did.
that. I appreciate how someone could be lost, and I'm not saying it wasn't as bad and droning as some of the other stuff. So I wasn't quite in that territory for me personally, but I still think overall it was a net loss.
Yeah,
and it was. I don't know to the degree to which the jury will be influenced by that one way or another. Maybe they just droned out and kind of it won't matter them one way or another, to be honest. But so it's hard to feel like how it's going to impact the jury.
I
What do you think,
really,
Nick?
well, I can't believe I find myself saying this, and I'm going to deny it if anyone points it out later. But I completely agree with uncivil. I think that my suspicion is the jury probably was just falling asleep for most of that last. It's not to say that she should have been doing it. I don't think she should have, but I think
Your mic keeps going in and out. Is it like
Oh,
a game
Yeah,
issue?
sorry.
I know it's
Yeah,
with your
no,
mic.
it's my bad. No, hopefully this will do it. If it doesn't, I can switch mics. But I think probably a lot of the juries already got their head wrapped around it. That you would hope, and then I think they're probably just droning this out and saying, "Look,
you're still going in and out.
All right, let me. I'll deal with my
to
mic. I'll be
hear you.
back in a second.
All right, sorry about that.
Nick with the mic problems, man.
How did the panel think she did on Brian, and what do you think?
I
the jury will do?
I didn't really feel like it was sold home. His connection to the whole thing feels off. I mean, he's guilty of aggravated assault with his truck because he ran Arbery into a ditch, right?
Yeah.
So he's guilty of aggravated assault, which is not nothing. But to show that he's a actor in the main crime is a little bit tenuous. And so I still think Bryant has some chances. Now, the problem, of course, is the jury and their degree to which they want to segregate information or not, because things have bleed over effects.
Testing.
So this of course goes both ways. So let's talk about it from both perspectives, right? First of all, by the overcharging, right? So maybe the malice murder is an overcharge.
1, 2.
We got you.
Okay.
So maybe the malice murder is an overcharge. If it is an overcharge, then by charging that, if the jury finds not guilty and they feel like the being disingenuous, that can read down. It can read to everything. And there are plenty of prosecutors who can tell you about the dangers and pitfalls of overcharging. For example, although I don't think George Zimmerman was guilty of anything, it was an overcharge. If he had been charged with something less, it was a better chance of not guilty. By charging second-degree murder for that crime, she hogtied herself. It was too much for what she was trying to get to. And so the same kind of problem here. But you can have the opposite problem, right? If you think that the McMichaels are guilty, then that can read on to Brian, right? Because they're all being charged together. So, although it shouldn't from a legal perspective, I'm not saying this is good, I'm just saying it's psychological. If the jury thinks the McMichaels are guilty, then it makes it easier to find Brian guilty, not for the reasons he's sitting right there and he's part of the common thing. So there's bleed over effects from all kinds of things that you have to worry about.
Yeah, I think for Bryant, if anyone has the best chance of getting off, it's Bryant, right?
Yes.
Because I think even though his attorney made some really bad arguments, I think the attorney made some good arguments that at least forced me to think. Why would someone videotape it? Why would someone give all of it? Why would they help the police get all this stuff, right? If this is somebody who had committed the crime and wanted to do this, why would he do all that, right? Why would he tell the police, hey, look, the guy was even I was just there and, I saw the thing happening. I wasn't trying to cut the guy off. The guy just ran into my truck. I'm just there on the street. That's why I videotaped it, because I was afraid for those arguments are convincing to me for Brian, right? But he's got the statement problem, right? He's made all these statements to police. I was trying to cut him off. This. Now that makes me think, well, that is false imprisonment. So it really depends on how dumb do you believe as a defense attorney and say he was just so dumb and he just made dumb statements, or do you kind of believe the facts as it is and say, okay, if he's really that dumb, we'll give him a pass. Racially charged case, one dead body, felony murder. I think he may have a problem. So for him, I'll say I'm not as sure. I think for the McMichaels, the problem is just the citizen's arrest. Mm-hmm. If that jury goes with the judge's ruling about the charge, that it extinguishes if you don't do it in immediately, they're done. I don't think there's anybody credible can tell you that they're not done. If the law is what it is, the jury would essentially have to say we're ignoring the law for Michaels to be found not guilty. That's essentially what we're talking about here. Is that possible? Yes. Is it likely? I don't know. I think the best for Michaels is maybe an acquittal, unless the jury just goes back there and just doesn't, just says, hey, we're all 12 of us are just going to just say, we're not going to follow the law. This whole reasonable clause, let us know what state you're in, but this reasonable cause upon citizens, but usually reasonable cause generally means probable cause. But I'm not sure how it is in your state.
To answer that question, we have to go into the case law, right? How's it been interpreted by the courts in the past?
But just to be clear, though, probable cause means we have crime committed and we have person who committed that crime, who we believe, right? So we have those facts, crime and person. Reasonable suspicion, we have person, but we suspect the crime, so we don't have crime. So if you can arrest on reasonable suspicion, that means I can arrest you believing that some crime has been committed, not knowing what crime it is. So that's the difference between reasonable suspicion. Reasonable suspicion is an investigatory tool. I can investigate to see if a crime has been committed. With probable cause is I can arrest you because a crime has been committed. That's generally the big difference between the two.
Well, and because it's a citizen's arrest as opposed to any kind of detainment, which you can't do. You can't detain them. So that's why the bar has to be higher, and they have to have personal knowledge of the crime having been committed. So they can't just stop them and they can't just run them off the road. There's a lot of very good reasons for that.
Yeah. Well, so what do you guys think the so it seems like I'm still guilty, right? I'm still, for the McMichaels, I'm still guilty, and I'm still guilty because I just don't think they can get over the legal aspect of it. So if the jury comes back and says that citizen's arrest is no good, they're done, right?
Yeah.
It's just a logical. But if they can get over that, then I think they got a shot. So I'm at still 70-30. I'm still at 70-30. I don't know where are you guys at?
I'd put it higher. For the McMichaels, I'd put it higher. I think you're looking at 90%.
You're looking at 90% conviction?
Yeah.
80-85 for me. Yeah, I think roughly.
Yeah. I wonder. It's too bad because this guy, law of self-defense, because he's adamant that they're innocent. He's adamant that they're innocent.
Well, I'd love to have him on. I sent him a link, so I don't know if he's not interested.
Yeah. I'm not sure because I'm not sure if he understands the judge's jury instruction because to find them well not innocent, not guilty, so we all understand to find the McMichaels not guilty, we are talking about jury nullification. The jury has to essentially ignore the law for the McMichaels to be found not guilty.
But
That's what we're talking about. This is not being biased. This is not anything. The judge's instructions are going to be in such a way where the jury has to essentially ignore the law to find them not guilty. That's a problem. That's a problem. And I know a lot of people are feel some way about it, but if you're going into jury deliberations with that,
they didn't know who he was. They didn't know what crime he was being committed of. They didn't suspect him of a crime. They didn't even know that he was reaching for the gun. That was a nice little ad. Was he reaching? Because the police asked them explicitly, and he said, "I don't know, but I want to say he was." Like, oh, okay, you're not even sure about that. What are you sure about? And nothing. They didn't recognize him. They were chasing him down day of. We just want to talk. We just want to talk with guns in tow. It's like the whole thing is ridiculous. So I think that this is, I think this is felony murder.
Well, and keep in mind, please, Nate. Sorry.
No, I just so everybody understands where we're going with this. Said Bronca did his own analysis before knowing the judge's charging instructions. Okay, and that's
I think even with the different instructions, I still think it's guilty. It's a different analysis, but I still get there, at least in my own head.
Yeah. I'm saying here, what I think a lot of people don't understand because people keep saying like grab for the gun. If we have, and people have to understand that the chain of events. The only reason they're able to conduct this to stop Arbery, point guns at him, and have that ability of self-defense is because they were conducting a lawful citizen's arrest. They've already admitted they didn't do that, right? Legally, they didn't do that. And because most people in the chat are still confused at it, that shows you how bad a job the prosecutor did in rebuttal. Because the prosecutor is supposed to tie that right back and say, here's the law, here's what they said. It's impossible for you to have self-defense in that instance. Well, I'm not self-defense. It's impossible for you to have a citizen's arrest in that sense. So that's what we're talking about. All
right, we're back on defense president represented by counsel.
Here we go.
Court has the charge. Let's go ahead and get the panel.
They're going to charge him now.
Well, and the dirty little secret about the law is it's not really about justice. It's not about morality. It's about keeping the peace, and it's about keeping people from murdering each other. And if you're gonna take the law into your own hands in one way or another, you really need to be sure you're right. And if you've broken the law, then it's not a question of whether or not or if a law applies very specifically, and that's what the judge did here. So even if people are sitting there saying what's unfair, I don't like his instructions, what he's saying is this is how the law applies. And there are reasons we follow that law. So, if they listen to those instructions, I think the conclusions. I think it's done. It's decided.
Yeah. It's hard to get over those, and that's why they were fighting so hard. And I got to give the defense attorneys a lot of credit. Bronca is basing his argument on plain reading of the statute, but again, if he's reading the statute and saying I can read it right, and he can disagree with the judge all he wants, but
I don't think
his reading of the statute is nonsense.
I don't think the case law supports his reading.
That's Marbury v. Madison, right? You go to the court, say I read the statute differently. Like, all right, so you were wrong, guilty. You can read the statute all you want. It's the court, it's the judge who says, well, this is what it actually means. And I know that's shameful. I know it's tough, but that's the way our law works. There's literally a doctrine in law called mistake of law for that reason. Possibly in some states. I'm not sure. I'd have to look up every state. Yeah, he's being charged with felony murder.
Well, she made the case.
Yeah.
Acting in concert.
But she was focusing on that when she could have just been focusing on, look, again, if it doesn't fit, you must have quit. Just keep hitting that one point because I don't have a choice on it.
It'd be interesting to be a fly on the wall when they're discussing Bryant's liability.
All right, welcome back, ladies and gentlemen. You are considering the case of the state of Georgia versus
Here we go.
Travis McMichael, Gregory McMichael,
This is the
and
ball game.
William R. Bryan. Now that the evidence and the arguments of counsel have been submitted to you, it becomes my duty to give you the final instructions of the court as to the law applicable in this case. As I told you at the outset, it is my duty and responsibility to ascertain the law applicable to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to ascertain the facts of the case from all the evidence presented. Then, you must apply the law I give you in the charge to the facts as you find them to be. It is your duty to follow the law as stated in the instructions I have given you and am about to give you. You should not single out one instruction alone, but must consider all the instructions as a whole. You have a sworn duty to decide this case based upon the law given you by the court and upon the evidence submitted during the trial. The defendants, Travis McMichael, Gregory McMichael, and William R. Bryan, in this case, have been indicted each individually and as parties concerned in the commission of a crime by the grand jury of this county for the offenses of malice murder, felony murder, 4 counts, aggravated assault, 2 counts, false imprisonment, and criminal attempt to commit a felony. The indictment was returned into court on June 24th of 2020. You will have the indictment with you at the end of the case, and you should consult it for the specific allegations brought by the state. The defendants have each entered a plea of not guilty to the indictment. The indictment and the pleas form the issues that you are to decide. Neither the indictment nor the pleas of not guilty should be considered as evidence. The defendants are charged in the indictment with crimes that are violations of certain laws of the state of Georgia. I want to emphasize to you that the indictment, including all of the counts therein, and the pleas of not guilty are the legal procedures by which these criminal charges are brought against each defendant. The charges in the plea of not guilty are not evidence of guilt, and you should not consider them as evidence or implication of guilt of any crime whatsoever. The defendants are presumed innocent until each is proven guilty. Each defendant enters upon the trial of the case with a presumption of innocence in his favor. And this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. There is no burden of proof upon the defendants whatsoever, and the burden never shifts to the defendant to prove his innocence. When a defense is raised by the evidence, the burden is upon the state to negate or disprove it beyond a reasonable doubt. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of another. You, the jury, must determine whether the state has proven the guilt of each defendant beyond a reasonable doubt as to each count. If, after giving consideration to all of the facts and circumstances of this case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit that defendant. But if that doubt does not exist in your minds about the guilt of the accused, then you will be authorized to convict that defendant. If the state fails to prove a defendant's guilt beyond a reasonable doubt, it would be your duty to acquit that defendant. Facts and circumstances that merely place upon a defendant a grave suspicion of the crime or crimes charged, or that merely raise a speculation or conjecture of a defendant's guilt, are not sufficient to authorize a conviction of a defendant. Now, your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses or the equivalent, such as depositions, any exhibits admitted during the trial, and stipulations of the attorneys. As I've previously charged you, a stipulation is an agreement between the parties concerning some fact or facts which you, as the jury, are bound to accept as facts during your deliberations. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. Now, testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. Now, the jury must determine the credibility of witnesses. In deciding this, you may consider all of the facts and circumstances of the case, the witness's manner of testifying, the witness's means and opportunity of knowing the facts about which they testify, the nature of the facts about which the witness testify, the probability or improbability of their testimony, the witness's interest or lack of interest in the outcome of the case, the witness's personal credibility insofar as it may have been shown in your presence and by the evidence, any evidence of bias for or against a party, any possible motive in testifying, if shown by the evidence. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters, and whether a witness has been impeached. The question whether a witness has been impeached is whether you, the jury, believe the witness has been proved unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Now, the defendant in a criminal case is under no duty to present any evidence tending to prove innocence and is not required to take the stand and testify in the case. If the defendant elects not to testify, no inference, hurtful, harmful, or adverse to the defendant shall be drawn by the jury, nor shall such fact be held against the defendant in any way. A number of statements that the defendants have allegedly made were offered for your consideration. Before you may consider any of these as evidence for any purpose, you must determine whether the individual statements were voluntary. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by a defendant offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. The defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by other evidence beyond a reasonable doubt that the crime alleged has been committed may constitute supporting evidence of a defendant's statement, if any, should so you find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify a conviction. If you find that there was a statement made by a defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of a defendant beyond any reasonable doubt. Any out-of-court statement made by one of the defendants on trial in this case, after the alleged criminal act has ended, may be considered only against the person who made the statement and only if you find that such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only as against the particular defendant who made it. Now, members of the jury, this court is responsible for determining the admissibility of certain evidence with regard to statements in this case. Sometimes full audio and/or video recordings cannot be played for you for legal reasons. You are not to make any inferences for or against either party in the case about the fact that the law does not allow the playing of certain recordings by the parties in this case. Now, evidence of prior difficulties or lack thereof between one or more of the defendants and Mr. Arbery has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendants and Mr. Arbery and the reasonableness of any
For
alleged
the
fears
1,000
by the
likes,
defendants or
Jameson
Mr. Arbery.
Black Barrel Whiskey.
Whether this evidence
One
illustrates
shot.
such matters is a matter solely for you, the jury, to
At
determine.
11 o'clock.
But you are
And
not
so-
to consider such evidence for any other purposes. Certain evidence of fingerprint comparison has been admitted by the court for your possible consideration. Identification by fingerprint comparison is opinion evidence and is dependent upon the credibility or believability and accuracy of the expert witness called for that purpose, as well as the following factors. 1, the validity of the theory of identification by fingerprint comparison. 2, the credibility of the witness who performs other necessary functions in making the comparison, such as inked finger impressions and latent lifts. And 3, the accuracy of procedures in identifying, preserving, recording, and maintaining integrity of the physical evidence, all of which are questions for the jury. Now, the defendants are charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by the statute. The defendants will not be presumed to have acted with criminal intent, but you may find such an intention upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused are being prosecuted. Now, every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of a defendant that a crime was being committed and that a defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that a defendant had no knowledge that a crime was being committed, or that a defendant did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense, then it would be your duty to acquit that defendant. On the other hand,
It's the process of attacking your
should you find
witness's
beyond a reasonable
credibility.
doubt
Actually,
that
the
a
accuracy
defendant
of
had
the witness's
knowledge that a
statement
crime was being
on the
committed
stand.
and that a
That's what
defendant
means.
knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict that defendant. A person shall not be found guilty of a crime if the act or omission to act constituting the crime was induced by a misapprehension of fact that, if true, would have justified the act or omission. Now, the law provides that criminal action shall be tried in the county where the crime was committed. Venue, that is, that the crime was committed in Glenn County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence, or both. The defendants are charged with the offenses of malice murder, felony murder in 4 counts, aggravated assault 2 counts, and false imprisonment and criminal attempt to commit a felony. I will now define the offenses for you. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that a defendant acted in the with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If the killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in a defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in a defendant's mind at the time of the act or the killing and moved a defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining a defendant's state of mind at the time of the killing. A person also commits the crime of felony murder when, in the commission of a felony, that person causes the death of another human being. Under the laws of Georgia, aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment are all felonies that will be defined later in this charge. You may find a defendant guilty of felony murder if you believe that he caused the death of another person by committing one of the felonies just described, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. A person commits the offense of aggravated assault when that person assaults another person with a deadly weapon or with any object, device, or instrument that, when used offensively against a person, is likely to or actually does result in serious bodily injury. To constitute such an assault, actual injury to the alleged victim need not be shown. It is only necessary that the evidence show beyond a reasonable doubt that the defendant attempted to cause a violent injury to the alleged victim or intentionally committed an act that placed the alleged victim in reasonable fear of immediately receiving a violent injury. As to count 6 of the indictment, the state must prove as a material element of aggravated assault, as alleged in this case, that the assault was made with a deadly weapon. As to count 7 of the indictment, the state must prove as a material element of aggravated assault, as alleged in this case, that the assault was made with an object, device, or instrument that, when used offensively against a person, is likely to or does actually result in serious bodily injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. In deciding whether a pickup truck is an offensive weapon in this case, you may consider all of the following factors: the nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, any other circumstances of the case. Whether or not, under all of the facts and circumstances of this case, a pickup truck, as alleged in this bill of indictment, did in fact constitute a weapon likely to cause serious bodily injury, is a matter to be decided by the jury from the evidence in this case. Now, on count 7, as to defendant William R. Bryan, you may consider the following lesser offenses which will be presented on his verdict form. Simple assault. A person commits simple assault when that person attempts to commit a violent injury to the person of another. Reckless conduct. A person commits reckless conduct when that person endangers the bodily safety of another person by consciously disregarding a substantial and unjustifiable risk that his act or omission will cause harm or endanger the safety of another person, and the disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in the situation. And reckless driving. A person commits the offense of reckless driving by driving any vehicle in reckless disregard for the safety of
I don't know.
persons
This
or
one has
property.
got me. I don't know. I'm more
If you do
concerned
not
than I
believe
was,
beyond a reasonable doubt
I'm a
that the
little
defendant,
concerned.
William R. Bryan, is
I don't know how
guilty
this
of
is going.
aggravated assault as alleged in
But I
count
like
7
these
of the
instructions a bit
indictment,
better than, I mean,
but you
it's
do
a little
believe
less
beyond a
folksy, but
reasonable
at least we're
doubt
just
that the
going
defendant,
boom, boom,
William
boom,
R.
boom.
Bryan, is
I, you know,
guilty of
it's
the
standard
lesser offenses
stuff. We're
just
not, this
listed.
is better than in the,
You would be
the House of
authorized to find the defendant,
Yeah.
William R. Bryan, guilty of the lesser and should so indicate on the verdict form. Continuing now with the charges set forth in the indictment. A person commits the offense of false imprisonment when, in violation of the personal liberty of another, he arrests, confines, or detains such person without legal authority. A person commits criminal attempt to commit false imprisonment when, with intent to commit false imprisonment, that person performs any act that constitutes a substantial step toward
Yes.
the commission of the crime of false imprisonment, which
The
has
answer to
been
this question is
previously
yes.
defined for you. Now, ladies and gentlemen, I charge you that whereas here in count 7 and 9 of the indictment, the state alleges that the defendants committed a crime in more than one way, the state need not prove that the defendants committed the crime in each way charged. Rather, it is sufficient if you, the jury, should find, beyond a reasonable doubt, that the defendants committed the crime in at least one of the ways alleged.
Andrew said they're going to be found not guilty. We'll see.
Now, ladies and gentlemen, the defendants have raised a defense that even if they committed the acts described in the indictment, there are circumstances that justify it.
here we go.
Once this defense is raised, the state must disprove it beyond a reasonable doubt. The fact that a person's conduct is justified is a defense to prosecution for any crime based on that conduct. The defense of justification can be claimed A, when the person's conduct is justified as the use of force in defense of self, or when the person's conduct is reasonable and is performed in the course of making a lawful arrest. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. The terms "in his presence" and "within his immediate knowledge" are synonymous in a crime committed in one's presence only if, by the exercise of any of his senses, he has knowledge of its commission, or by the accused admitting that such a crime is being or has been committed. A private person may not act on the unsupported statement of others alone. A private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies, during escape. If the observer fails to make the arrest immediately after the commission of the offense, or during escape in the case of felonies, his power to do so is extinguished.
And they're not even observers at this point.
A
Yeah,
private
that's the death
person may
knell right
arrest an offender upon reasonable and
That line
probable
was the
grounds of
death knell.
suspicion, that is, on probable cause, which is defined as facts and circumstances that are sufficient to warrant a prudent person or one of reasonable caution in believing, in the circumstances shown, that the suspect has committed an offense. The facts necessary to establish probable cause for arrest are much less than those required to prove guilt beyond a reasonable doubt at trial. The test merely requires a probability, less than a certainty, but more than a mere suspicion or possibility. In determining whether probable cause exists, the totality of the circumstances must be considered. Whether probable cause existed is for the determination of the jury. Now, an arrest is defined as the taking, seizing, or detaining of the person of another, either by touching or putting hands on him, or by any act indicating an intention to take such person into custody, and which subjects such person to the actual control and will of the person making the arrest. An arrest can occur even when a subject is not told that he is under arrest. A person is authorized to use, in making a lawful arrest, only that degree of force that is reasonably necessary to accomplish the arrest. The mere fact that a lawful arrest is being made does not give the person the right to use excessive force or an unlawful degree of force upon the person being arrested. One upon whom an illegal or unlawful arrest is being made has the right to resist the arrest if such force as is reasonably necessary. Let me read that again. One upon whom an illegal or unlawful arrest is being made has the right to resist the arrest with such force as is reasonably necessary to prevent the arrest. A person commits the offense of criminal trespass when that person knowingly and without authority, A, enters upon the land or premises of another person for an unlawful purpose, B, enters upon the land or premises of another person after receiving, prior to entry, notice from the owner, rightful occupant, or, upon proper identification, an authorized representative of the owner or rightful occupant that entry is forbidden, or remains upon the land or premises of another person after receiving notice from the owner, rightful occupant, or, upon proper identification, an authorized representative of the owner or rightful occupant to depart. A person commits the offense of burglary in the first degree when, without authority and with the intent to commit a theft therein, that person enters or remains within the dwelling of another. For purposes of this law, a dwelling includes any house, building, or structure which is designed or intended for occupancy for residential use. It makes no difference whether the building or structure was occupied, unoccupied, or vacant. However, you may consider occupation status in determining whether or not the structure in question was designed or intended for residential use. To constitute the offense of burglary, it is not necessary that it be shown that a break-in occurred. To constitute entry, the evidence need only show a breaking of the plane of the structure alleged by the offender, or by any part of his body, or by any instrument controlled by him. The evidence need not show that an actual theft was accomplished. However, an intent to commit a theft, that is, an intent to steal, is an essential element of burglary. You may infer an intent to steal where the evidence shows an unlawful entry without authority into the place of another where items of some value are present or kept inside, and where there is no other apparent motive for the entry. Whether or not you make such an inference is a matter solely for you, the jury, to determine. Person commits the crime of hijacking a motor vehicle in the second degree when such person obtains a motor vehicle from an individual without his or her consent. Now, the defendants have raised affirmative defenses claiming that even if the acts described in the indictment were committed, there are circumstances that justify them. Once an affirmative defense is raised, the state must disprove it beyond a reasonable doubt. The fact that a person's conduct is justified is a defense to prosecution for any crime based on that conduct. The defense of justification can be claimed as self-defense and as citizen's arrest. Sometimes a defendant's threat or use of force is legally justified, so is not a crime. Let me read that again. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in threatening or using force against another when, 1, he reasonably believes that the threat or use of force is necessary, 2, to defend himself or a third person, 3, against the other person's imminent use of unlawful force. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, 1, he reasonably believes that the use of such force is necessary, 2, to prevent A, death or serious bodily injury to himself or a third person, or B, the commission of a forcible felony, which means a felony that involves the use of force or violence against another. Aggravated assault is again a felony, which can occur by use of fists if they are used as an offensive weapon. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide a defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in threatening or using force if he provokes the threat or use of force, intending to use that threat or force as an excuse to harm the other person, is committing a felony, aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment are felonies that have been previously defined, or is the unjustified initial aggressor unless he withdraws from the encounter and clearly communicates to the other person his intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. For a defendant's threat or use of force to be justified, 1, the defendant must believe that his threat or use of force is necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary. And 3, the defendant's reasonable belief must be what prompts him to threaten or use force. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. A defendant is not justified in using excessive force while acting in self-defense. If you decide that a defendant used more force than was reasonably necessary to defend against the alleged
The jury's
victim's
going to get a
threats
copy
or
of all
use
this,
force,
right?
then the defendant's actions would not be justified.
Yes, yes.
Now, if, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that a defendant in Glenn County, Georgia, did on February 23rd, 2020, commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that a defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of another or all. You, the jury, must determine the guilt or innocence of each defendant separately. You will be given a special verdict form for each defendant to use when you retire. You are to consider each count separately. In the space provided on the verdict form, you will indicate either guilty or not guilty depending on your verdict for that count and that defendant. Now, I want to emphasize that anything the court did or said during the course of this case was not intended to and did not intimate, hint, or suggest to you which of the parties should prevail in this case. Whichever of the parties is entitled to a verdict is a matter entirely for you to determine. And whatever your verdict, it must be agreed upon by all of you. The court's interest in the matter is that the case be fairly presented according to the law, and that you, as honest, conscientious, impartial jurors, consider the case as the court has instructed you and return a verdict that speaks the truth as you find the truth of the case to be. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to any party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. Now, you are only concerned with the guilt or innocence of each defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you as to be the foreperson who will manage your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. During deliberations, you must not communicate with anyone other than your fellow jurors about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, still a BlackBerry in this, computer, the internet, any internet service,
It's
or
like,
any
damn, they still got
text
Blackberries on
or
this
instant messaging service, or any internet chat room, blog, or website, such as Facebook, MySpace, LinkedIn, YouTube, Twitter, the list goes on and on. You cannot use any of those to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Whatever your verdict is, it must be unanimous, that is, agreed by all, as to each count of the indictment and as to each defendant. Each verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. I do ask whoever the foreperson is, please write in pen. Please don't sign the verdict form in pencil. Now, ladies and gentlemen, you may retire to the jury room, but do not begin your deliberations until you have received the indictment and the evidence that has been admitted in the case. We do need to separate out the three alternates. Three of you are alternates, which we will separate out for deliberations. The three alternates will continue to be jurors in this case and still subject to all of the instructions of the court. If at some point during the proceedings, one of the deliberating jurors is not able to complete their duty for the court, then the alternate will be brought into deliberations and deliberations will begin again with that alternate. So with that, ladies and gentlemen, I ask that you retire to the jury room.
All right for the jury.
That's it.
All right. So here's the deal. I'm gonna
Go ahead.
hijack the stream to shill for 1 second, and what I want to say is there's so many people watching this right now, and I know a lot of them aren't like watching the live chat and saying, you know, hey, like and subscribe. So I want to say this aloud so everyone can hear it. Nate does this because he loves it. That's why he does it, but he can only do it if he's supported. So many ways to show support and love. But if you've been watching this, you know, if you're just listening and not watching, pause, pull over, do whatever you got to do. Hit the like button because that's the way you show them that you like it. If you show them you like it, that's what keeps it going. You're not paying for this. You're not. So like and subscribe. It means so much. And it helps everybody. We all know Unlawful and I both have channels. We know what it's like. It's so much work. He's been doing a great job. Show him.
Just renewing our previous
We got 2,000 watching. Show him. Take a sec.
Yes, just
And you get
renewing
good
the
content.
previous
It's worth it.
objections.
Go do it. That's it. Thank
and
you.
Exceptions, excuse me.
Yeah, I appreciate
which
that.
include the
Please check out our
reasonable
channels.
charge, the one
And check out In Time's channel.
and then
Subscribe, do the
later
YouTube things.
charge
Do the
Help me
YouTube
hit
thing.
50,000 by the end of the year.
last
That'd be
sentence
great.
of
I'm
the
at 42.
paragraph concerning
Nice.
the
So
synonymous
just need
terms,
8,000 more, man.
in his presence and within his immediate knowledge, accepted to a private person may not act on the unsupported statements of others alone. And then the entire next paragraph concerning contemporaneity of the offense and the actions of the person.
Yeah, thank
making
you.
arrest.
The final for Mr.
And I
Brown.
believe the court has already indicated that the arguments made by email on Saturday, November 20th, I believe it was, will be put into the record in support of those exceptions.
notice of filing. For Mr. Brown.
On behalf of Mr. Brown, we renew the objections to the charge and exceptions made thereto. And although I don't think it's necessary, we will also renew the many motions for mistrial that were made during the trial of the case.
All right, let's go ahead and check the evidence then. It is this court's practice with firearms not to send out the live ammunition or the weapon itself. And I also don't send out the videos. Normally these days, jurors don't have the ability to play the videos, but given the court's position is if there's a request to replay a video, it needs to be done with all the formalities of the court. And so they can go ahead and request that, but we do that here, so I don't send them out.
Your Honor, do you have the verdict forms? I don't know if I've.
I do have, if I could have y'all take a look at the verdict forms to see if there's any objections to the verdict forms. I also have a copy of the charge that I will give to the clerk as courts 5, I think we're on, which will be courts 5. That will go out to the panel. Go ahead and take a look at that before it goes out also. So I got the verdict form and the charge.
I could inquire before we end.
I'm sorry?
If I could inquire before we end.
Good.
Go ahead. Did the court take some more time to think about whether the court would bring the jury in and ask them in front of us if anything has come up? We wanted to see that process happen.
I did. I don't think it's necessary here. Today, there's very few, if any, people out front that I'm aware of. I haven't heard of anything or any issues. Again, last night, the only reason I moved the jury is because after getting permission from counsel to go into the jury room, I had heard, probably not as I was walking in, but I heard as I was talking to the panel, something that sounded like a crowd outside, and asked the panel whether or not they heard that. And the response was they just heard that too. And I thought in an abundance of caution, not really knowing what exactly was happening outside, that I'd go ahead and move them into one of the interior courtrooms. That apparently was, there had been movement outside. There was a protest group that was walking around the courthouse. I believe what the court did yesterday was appropriate under the circumstances and actually consistent with some of the requests that have been made by counsel. I did not do it because I felt there was any safety concerns or any other problems. I simply did it in an abundance of caution. I don't want to go into where they are now, but I'm satisfied today there have been no issues whatsoever. And so no, I don't plan on going into that inquiry. But I do recall the request being made. I'm satisfied that there have not been any issues along those lines.
And I guess I would be joining in that. The record is what it is, but I don't believe the court has inquired of the jury affirmatively a single time from their empanelment to this moment. And I don't think it would be inappropriate, given all that has transpired in the public gallery and outside the courthouse in this case, for the court to inquire affirmatively at least once of this jury panel. Having said that, I'm going to sit down.
Let's go ahead and check the evidence. The proposed verdict form should be somewhere in the as well as the, I'm sorry, they're right here. And let's go ahead and do that so we can get the evidence to the panel.
I had, and I just want to make sure this is consistent with what everyone else in the court has as the 3 alternates. Currently, I'm going to use their current numbers. 14, 13, and 6.
I'm going to have, yeah, it's mine's, I will find that. I didn't realize you were going to bring that up right now.
Do you have their original numbers?
Next to the current numbers.
Yep.
Yes. You also want the
Yeah,
original numbers? Original numbers. 773. That was for 14. Correct. 364 is number 13. And 440 is number 6.
I believe that's correct.
Agreed.
Agreed.
All right. In addition, I will get with defense counsel about the method that the evidence is in right now, where it is in file folders labeled with the numbers, and we'll go through it.
That's good. I'm going to stay on the bench until we have all these formalities addressed. So once we know we've got all the evidence together and everybody's had an opportunity to look at the verdict forms, we'll get that addressed.
All right. I think we can. So where we at? We're waiting for a verdict at this point in time.
Yep. About where
What do you
we're
guys
at.
think?
There's a lot for the jury to consider here with the multiple different charges and multiple different people. So I wouldn't be surprised if this goes longer than, today, because there's so much information to consider depending on how they want to evaluate the various information. So, I don't know that we're going to get a quick verdict. They're getting it relatively early in the day, though. It's only 11:30 there. So they've got like 5 hours worth of deliberation. So, maybe later today, but probably by, and we also got the fact of course, Thanksgiving is coming up rapidly.
Mm-hmm.
So you don't want to go, you're obviously not going to wind up probably past Wednesday. So people might have flight plans and all the rest of it. So yeah, I think a verdict by the end of tomorrow is probably reasonable.
How do you feel, Nick?
Yeah, I'm on the same page. That's what I'm thinking. I don't think they'll do it today, even if they reach the conclusion that they all agree and want to do it today. I think if you're on a jury, you don't want to make it look like you didn't deliberate. So you don't want to come back necessarily too early anyway. And there's free lunch. So, I think they may. I don't think they'll do it today anyway. I think there is a lot to consider. So I think they'll. I'd be surprised if it's not by end of tomorrow. Yeah.
One thing, your volume is really going in and out. I don't know
Lord.
what's
All right,
going on.
let me get as close to the mic as I can. Hopefully that does it, and otherwise I'll just shut up. So this is why I always start muted on the show.
Let me turn your mics back to automatic. There we go. So now everybody should be able to hear us clearly. All right. Yeah, I'm it's weird because I'm thinking that if that rebuttal was better, I thought we could have got one today. But the rebuttal was just so convoluted and so, it was confusing me, right? And I'm a lawyer, so I was confident today may be the day. But just so everybody understands my thinking, juries are people. Thanksgiving is Thursday, so do you want to go in Thursday without this being done?
Yeah.
So I'm thinking that jury is going to be working as fast as possible to try to get this thing done, because if you get it done by Wednesday, then you get Thursday, you're probably off work Friday, and you get to have a nice holiday. If it goes past Wednesday, then you're talking about being off Thursday, maybe possibly having to come in Friday, right? And if the judge gives you off Friday, then you're talking about coming in Monday and having to do a whole nother week and taking off more work and all this other stuff, right? And getting ready for the Christmas. So it's like, do we want to get this done before the holiday? That's number one. So I believe it could be, it's possible. But I believe if the jury takes a long time to deliberate, it's bad for the prosecutor. The longer it goes, I think the worse it is for the prosecutor. Because the law is just so blatantly on the prosecutor's side.
Mm-hmm.
Blatantly.
All it takes is for one, though, to decide that for whatever reason, they're going to stand their ground on one issue, and then it just holds out forever. But so short of that, I think they're done tomorrow.
Yeah, that's my concern, is that if you have one person holding out for a while, then that's what we're looking at. I think there's a lot here that the jury can hold his hat on to get it done by tomorrow. And I think the key issue here is the citizen's arrest. They've literally and I don't know why she didn't combine it. She didn't say they've been arguing. It didn't happen in their presence. The law requires it happens in their presence. We're done.
Yeah.
Right? We're done. I didn't hear anything like that to meld those two. And that jury instruction, it's not like I sat here and listened to that jury instruction. I was like, oh, it's so clear. I understand it now. They couldn't. Right? It wasn't put together. And I think the prosecutor made a critical error in not putting it together. Now, maybe the jury can be smart enough to do that, but by her not doing that, now it kind of and she's talking about you should start with, what did she say? She should start with false imprisonment or something like that. No, you start with whether you're authorized to do that. You got to start with, I would have said you guys, my opinion is start with whether the citizen's arrest was legal, because they said it wasn't, right? They said it wasn't. And we've proved beyond a reasonable doubt it wasn't, right? Based on what they've also told us. So
how often do you get handed something like that by a judge? I mean, seriously, where the judge is just like, I mean, it's almost a directed verdict right there, saying this is the defense's argument can't be considered for. I mean, that's not that common, right?
Well, it depends. It depends what the reading of the law is, right? So the judge gives a reading of the law, but it's weird the defense didn't lock that down before the trial started in terms of the reading of the law.
So bad. One thing I've also a couple of things that we should be clarified for all the people who are watching right now. It should be abundantly clear. There are still people out there saying that they need reasonable suspicion for an arrest. You literally just heard the jury instructions, and the jury instructions clearly not only said they needed probable cause, but defined it for us. So anyone from this point in time out there saying that reasonable suspicion is necessary for an arrest in Georgia is objectively wrong, right? If you hear that from the mainstream media, if you hear that from Officer Tatum, whoever you're hearing that from, they're wrong, right? It's just this. So that's cleared up. I think the biggest takeaway here, if the jury's going to have a problem, it's really going to be on Bryant. I believe it's really all or nothing on Bryant. Do you believe him? Do you not? That's it. But I think the McMichaels are done. And my last point on the McMichaels, malice murder. I'm saying not guilty. I'm saying they're not guilty of malice murder, right?
Yeah, I agree.
I don't think you've gotten it. And I think that overcharge could also hurt, because you don't want a jury starting to say not guilty and then start rolling a not guilty of all this stuff, right?
Right.
You've already given them the not guilty, and now they just roll it down the jury form. So I think malice murder, if hopefully this jury understands malice murder, they're not guilty of that. But the felony murder, I think you obviously got it guilty, because you don't have the citizen's arrest. I think the whole self-defense thing, I think that's nonsense, right? If they're committing a felony, you don't have that. But I really think right now this is really going to be whether the jury is able to understand that the McMichaels have already admitted they couldn't have made a lawful citizen's arrest under Georgia law.
Well, and I mean, I think that's already game, set, and match there. But also, when you had the officer who said that the trespass, it was not what was it? It didn't rise to the level of, it was a misdemeanor.
Burglary.
So,
it was a misdemeanor.
It was. And so when you had that too, and that's all that they had been told about, was essentially a misdemeanor. I think it's already game over, but that's
What do you guys think about that fact? That's a good fact. Unsub, what do you think about that fact? The fact that when they asked the officers on that day, the day they said they saw the burglary, or the burglary was committed in their presence, the officers said, well, we don't have burglary, we got criminal trespass, and we're going to trespass him out if we ever catch him. Does that, I think that kills the burglary argument. I think, if you get past the citizen's arrest argument and say, all right, we had a citizen's arrest. For what? Yeah, because they've attacked it in two different ways. They've attacked it based on the burglary, and then they've attacked it based on this other way. So I don't see how you get there. Am I wrong? It's okay to disagree with me too.
Well, I'm thinking about it in my head a little bit, because I'm trying to make the determination of, just because the police officers say effectively we don't have probable cause, does that necessarily preclude them from reaching the conclusion of probable cause? Because I mean, officers could disagree amongst themselves as well, right?
So, yeah, but they didn't see anything
at the time. True. Yes.
Well, okay. But I think that's important. Am I missing something?
I'm not disagreeing.
Oh, okay.
I was just focusing on what I understood the question to be asking about what the officers said to them and influencing their mental state. That's what I understood the question. Was that the question?
No. You're right. Fair point. So
okay.
You're just talking about.
I'm just trying to answer the question put before me, man. One question at a time, right? Yeah. So I don't think so I'm trying to say, well, does that necessarily preclude them reaching the conclusion? Because officers might disagree about whether there's probable cause.
Of course.
So as to whether or not they had probable cause, I think because they didn't know what they were arresting him for. They had suspicions. The fact that police officers said that certainly would be a weighing factor in their mind that would help to potentially preclude that. But I don't know it's necessarily a causal. Just by way of personal note on that one, Nick. It's interesting because I don't know if I'm not making these things clear when I'm answering these kinds of questions, or I'm doing it on my channel, where I'm moving different frames of reference, because I'm always trying to analyze like one thing at a time, and people sometimes seem to get confused. So if you were confused, then maybe I need to do better on like making clear what I'm answering or something.
No, I think you should keep doing exactly what you're doing. I think what I did was what I took it to be in the context of specifically in this case, in what's going on and this fact pattern. And I think what you did was you just answered in terms of just the one question that was asked, right? Okay, just because. And I'm saying, yeah, but that doesn't apply here because so I think you were answering explicitly the question on its own terms, and I think that's really important. It just until you realize that someone's doing that, you're like, hey, wait a minute, and I was just like, no, you answered you explained it. So no, I think you're good. Keep doing that because you need that. So
yeah, it's interesting because on my channel, like sometimes I'll flip frames of reference, or I'll make different arguments from different propositions, and it seems like sometimes people in chat have difficulty keeping up with that. For when we're going to the Arbery thing, or apologize to the to kill Rittenhouse thing, for example, changing frames of reference. It's like, okay, so let's look at this from Graswich's point of view. Let's look at it from Rosenbaum's point of view. Let's look at it from this point of view. Let's look at it from that point of view. And I even made a point at one time saying, and I thought I was pretty clear in the chat where I was like, not that they need to, but I think the defense proved beyond a reasonable doubt they had self-defense. It's still in the chat. I'm getting uncivilly. That's not the law. You're a bad attorney. I don't want you as my attorney. I'm like, man, geez, I don't know what's going on sometimes. It's very frustrating sometimes.
Listen, I don't want you as my attorney either, but that's only because I don't want to be on trial for anything.
Oh my God.
I think you want an attorney who can look at things from multiple frames of reference, because whether or not you're suing anyone, whether or not you're suing or whether or not you're being prosecuted, it's like you want an attorney who can try to put themselves in the other attorney's head, try to put themselves in the other party's head, try, at least in their own head, to steel man their arguments so that they can build up better arguments for you. That doesn't mean they're going to think of everything, but it means they'll think of some things. At least they're trying.
Well, and you're talking the law. You're not necessarily giving like, oh, this is what I think should happen. And you do that and you say that when you, but if you don't say that, then that's not what you're doing. When you say this is my opinion, then it's but if you haven't said that, then you're just talking the law. And that sometimes it's crazy, but it is what it is, and you can't change that. None of us can.
But there are many times where the law disagrees with my personal opinion. Like, what was the case? The case of the kid in Colorado, Elijah McClain. I vehemently disagree that those cops were able to do that, and that poor kid died, and that nobody was held responsible. Right? I disagree with that personally, but that was the right decision, not to charge those cops and to find what they had done to be lawful. Right? That was the right legal decision. I disagree with it, right? Personally, but I'm not going to sit here and tell people that was a wrong legal decision, because it wasn't. It was a correct legal decision under those circumstances, the law as I understood it. But it's sometimes it's tough to do that, and I think that's the reason why, a lot of times people get these rulings a lot of times wrong, because they kind of substitute their attitude for the law and say, well, I believe this is just so wrong that it should be illegal. And that's what I think a lot of people caught up in Kyle Rittenhouse case. How can a kid go to a protest and shoot?
How can he cross state lines with a fully automatic AK-47?
AK-47.
And then you look at the law and look at what happened and say, okay, this is actually what happened. And it's tough, right? Nobody's being held responsible, but it's not because the law is wrong. It's just because of the situation that happened. This question I want to answer.
Can I bring up one thing?
Hold on.
Okay.
Well, let me answer this question because it's been up. How far does immediate knowledge extend? All right. So there's two things with this is talking about the citizens arrest statute, and there are two parts to it. One, immediate knowledge, and the judge even said it, that they're synonymous, in your presence and immediate knowledge. So if you are in your presence means I'm sitting there, I can smell it, see it, hear it, taste it, touch it. That's immediate presence, right? I actually don't have to see it. It can happen behind me and I can hear it. That's immediate presence. And immediate knowledge is the store shop owner who's looking at a video and sees the person take the item and then goes downstairs and confronts that person. That's immediate knowledge. Now, the big issue in this case is that if you don't arrest the person within that time, then unfortunately, if you don't arrest the person within that time, then your right to conduct the citizen's arrest extinguishes, right? So I see them on Monday, and they get away. I cannot arrest them on Tuesday. So don't get those two things changed. I can arrest them all. If I can arrest them under citizen's arrest on Monday and I don't arrest them, Tuesday, I have no right to arrest them. And that's what's happening here in the Ahmaud Arbery case. They're saying we had the right to arrest them on Monday, and then on Friday we saw him, so we tried to arrest them. No, their right to that citizen's arrest extinguished. What's going on? And want to say hi to Eric Hunley in the house. What's going on, Eric?
Hey, Nate. I'm here as the civilian that knows nothing, and I did have one question about the
position's already filled, but all right.
I cannot do you, I'm sure. I had one question that the judge in his instructions brought up, and it was just the terminology. He said that essentially, if you don't find the evidence or whatever, you must acquit, and then he said, or you may convict. That rule, that statement in my head allows for jury nullification.
They did the same thing in the Rittenhouse trial too. It was the same exact wording that I caught too. So I don't know about that, but I caught the same thing.
Yeah, I'm not sure.
Yeah,
It's pretty standard language, but we'll see. We'll see.
Well, it's
Because
significant. It's significant.
It is
language in my
significant,
mind.
I did want to make a point because I want to go back to the other thing about understanding these kinds of things is people will say, well, okay, and I do want to use Rittenhouse for a second. He had a gun that's brandishing. In Massachusetts, it would be. And in my state, okay, it would be. But what people don't necessarily realize is there are 50 states, 50 set of laws. And you have to understand that the law is going to be applied not based on where you are or how you understand the law, but where they are. And because it's an open carry state, just walking down the street with an AR-15, it cannot be brandishing. It by being open carry, the two are incompatible with each other. It's not brandishing to just have the gun out in the open in an open carry state. By definition, it's not brandishing. So while people from my state are watching Rittenhouse and they say, how can him walking down the street or just being out there with the AR-15, how is that not intimidating? How is that not brandishing?
Because Wisconsin's free, unlike you commie states.
Oh, you son of a. Well, at least listen. Okay, it took you how long before you started to go off on the right-wing gun nut stuff? But thank you for that. All right.
Where are you located?
Massachusetts.
Okay, I already have a problem with you because you have to go to buy beer. So that's proof enough that you're not free. If I can't buy beer from a grocery store, dude, you've got deeper problems.
We're civilized. We're civilized, sir.
Yeah.
But that's all right. I know. I understand. I understand you. AR. What is it? The AR-47 or 57 or whatever carrying folks have no idea what.
Boston Tea Party. Boston Tea Party. What happened to you guys?
Yes,
what happened to you guys? You used to be the ones. What happened?
Freedom, live free or die. Right? Is that the plate? Live free or die.
No, that's New Hampshire.
New Hampshire. All right.
Yeah, you see, they all ran out of Massachusetts and said, "Hey, we got to try again."
What is the legal basis for saying the right to citizen's arrest extinguishes, i.e., show the statute? I didn't see it in the statute. This is what's called case law interpretation, right? The courts have read the statute, and you have prior cases, and in those cases, the courts have determined that your right to a citizen's arrest extinguishes if it doesn't happen in that immediate time. And the reason why is because there are two actual reasons. One is because it becomes a status crime. A status crime is if you've committed this crime on Monday, and someone can say, if 2 years later, someone can say, well, I saw you commit a crime 2 years ago, so by your status, I can arrest you, and I can arrest you 2 years later. The law doesn't allow that, right? And the second is that if the citizen doesn't arrest the person in that moment, and let's say the person gets caught by the police the next day, and it's adjudicated where the person is found not guilty and is free, then you'll see that person next month, and that person would not have been, the crime is over, right? There's no crime. They've been totally exonerated. And now you're saying, well, I'm still arresting them based on the probable cause I had 2 months ago or 2 weeks ago. That's the reason why it extinguishes at that moment. That's just taught on the case law. So you're right. You won't see it in the statute, but but I think people need to understand, and this is mistake of law. This is the mistake of law doctrine, where it's not a regular citizen should be able to read the law. But if you're reading the law and interpreting it wrong, it's on you. There's a famous case in New York where this happened. There was a what's it called? What's the guy? He was what do they call the people who guard the jails? A corrections officer. He was a federal corrections officer. And the state law said that if you're a corrections officer, you can carry a gun. So the guy goes to a gun store. He's a federal corrections officer. He goes to the store, to the gun store, and says, "Hey, this is me. Here's my badge ID. I'm a federal corrections officer, right? I can have a gun." That the statute's talking to me. The gun shop owner read it and said, "You know what? Damn right. That is you." Sold him a gun. Eventually, the guy gets arrested. They say, "Hold on, you got an illegal gun." He says, "No, I'm a corrections. I'm a federal corrections officer. It says statute right here, corrections officer." Goes to court. All the way up to the Court of Appeals, the highest court in New York. New York court said he misread the statute and upheld the conviction because the statute was actually limited to state correction officers.
Excuse
So
my
federal
language,
corrections
but
officers
I'm
weren't
going
there.
to call bullshit on that.
It is bullshit. I'm saying it's bullshit. I'm agreeing with you
because I speak
That's-
English, and the law is supposed to be based on English. And if they wrote the law improperly, I understand they want to hold up because they look bad, but that there should be some responsibility of the people drafting the law to make a clear law. And anybody with a lick of sense can read that and say, corrections officer didn't specify. Here you go. Have a nice day.
I agree with you. I agree with you whole. I think that was a poor decision, but that's the danger of mistake of law, because only certain people are allowed to actually even interpret the law and tell you what the law is. Like, a judge, for instance. Judges are authorized to determine what the law is. And you're right. It's totally bullshit. That guy shouldn't have been, but that's the state of the law now. And there's a whole doctrine of mistake.
Has it gone higher? Yes. That one should go all the way up, I feel.
Well, that's it. It was under state law, so I don't think the feds can.
Oh yeah, there's nothing to appeal to the U.S. Supreme Court, but Georgia Supreme Court, maybe they'll get a piece of it. Sure,
maybe, yeah. If guard A watches you steal something on camera and tells guard B, who is on the floor, is that immediate knowledge? What do you think?
It's technicality. I'd say it's as immediate of knowledge as you're seeing it on a video. You're not seeing it with your own eyes. You're seeing it through an interpretation. So somebody yelling, "Hey, stop that person, stop them," around the corner. I didn't see them grab the purse, but they're coming around the corner. So I didn't see the act. I would say that's pretty immediate knowledge. I don't know.
We make it even broader than that. Just out in the street, someone says, "Stop that person," who doesn't appear to be wearing any kind of uniform or appear to be in any kind of authority, as someone's running away.
Right.
It's like, well, why? Maybe they were shoplifting. Maybe this is a bad actor who's trying to get
not.
For,
yeah, I don't know.
For whatever reasons, he stole my drugs.
Well, yeah, maybe he just shot someone in self-defense and is being chased by a whole crowd.
Yeah.
Who the hell knows what's going on?
So I think the answer from my mind is probably yes. The knowledge might be wrong, but that's okay because that's not a mistake of law. That's a mistake of fact.
Yeah.
Right. So when we talk about there's the difference between mistake of law and mistake of fact. So when you have a law that says you have to have knowledge, if someone says to you, "Well, that guy just stole my purse," and you go chase him down and stop him, and that turns out not to be true, right? It's not that you misunderstood the law. It's you misunderstood the facts. Oh, I had a reasonable belief for believing this. So you're not guilty because you don't have the mental state in the law.
Correct. Yeah.
So, but I think, yes, I think it gives you immediate knowledge, whether or not that knowledge is mistaken. I think that's probably correct.
Yeah. If especially if you're working together and the person's up to the cameras, because that happens in stores all the time. The guy who's on the camera, "Hey, there's a person," and they're very specific. That would give you I think that gives you probable cause to make the arrest. On his channel, Andrew seemed to make the case for innocence.
Yeah, can you get him on? He's been live tweeting this all morning.
I'd be thrilled to have him. I sent him the link. I'm not sure if he ignored me or whatever, but I sent him the link.
Oh, maybe. But
it comes from you. I don't know.
Maybe. I'll resend it to him.
But he doesn't follow me, so.
But I would suspect, but he didn't. The one thing though, and a couple of people mentioned it earlier. I do have to give Andrew some leeway here. Number one, he didn't see the whole battle with the jury instruction, so he didn't see that whole thing with the jury instructions where the judge more or less, killed the defense's case and the fact that the defense conceded. So he didn't see all that. So his reading of everything is just based off the closing arguments. So he didn't understand the underlying law that they were arguing to. So I think you have to give Andrew a break. And Andrew still could be right too. But I think Andrew just is missing the point that the only way this jury can come back the only way this jury can come back and say this is a citizen's arrest is literally through jury nullification. And the defense has already conceded that, and the judge has already conceded that. That's what we're looking at.
So, if let's say, okay, this goes through, they're convicted, all of them cross board, whatever. And then an appeals court, obviously, will go in, and the appeals court say, no, judge, you were wrong. That is not the law. What then? Because I think that's where it's,
we get a free do-over. Yeah, you get a do-over. You get a do-over. And that happens all the time. That happens all the time where, because a lot of these issues don't come up, right? All the issues that we see come up, they start at the trial court level, right? And they go up. So all the famous cases from Roe v. Wade, that started at trial court. And a judge had to make that call at trial court. Okay, she doesn't have this right. And then it goes into the Supreme Court. So this may be that case where the judge says, this is it, and then it goes up, right? So I think the ruling can go. I can see an appeals court coming back and saying, no, he's wrong. And then you do it again. So that's definitely possible. Do you think the fact that Georgia's governor repealed the citizen arrest law after this happened still? No. Because they have to be prosecuted.
Ex post
under
facto,
what the law
baby. You
was.
can't go backwards in time.
Yeah. Being a gun nut doesn't make you a right winger. That's true, because I'm a gun nut now. I don't consider myself a right winger.
I agree. You are not.
But I do feel like I'm a gun nut, though. I am, though. I love them. What is the worst question you've heard a prosecutor ask a jury pool during jury selection? That one I have to think about. Are you going to cover but that one is going to be tough to cover. It's not up. It's no.
Apparently there's audio.
Explain wax melt. Yeah, the federal district courts don't do. They do audio.
That's what I was talking to Andrew, Legal Mindset, earlier on Twitter, and
we can put up a picture of the courthouse, I guess, and do the audio thing.
Well, maybe listen to it. I was saying you should probably listen to it, find segments, clip them, and then analyze it later or something.
Yeah, probably.
There's a couple decisions on that already. I think they're fascinating. First one, and this one's majorly important. It just came out today. Elizabeth Loftus has been approved to come in as an expert witness, and she was tied in with the Macmillan's preschool and is the top flight psychiatrist that proved out false memories. Where an expert can get a witness to remember being touched in a certain way, things like that. And this was a chronic problem that was in the Satanic Panic years. I don't know if you remember any of that. She was the key figure in the false memories front. So the judge allowing them to bring her in as an expert is telling you already where this may be going. And she's not a lightweight. You're muted, Nate.
Oh, no, I was talking about I told them I should be finished in about 10 minutes because I'm going to cut this. So everybody understands. In about 10 minutes, I'm going to cut the stream and then we'll wait, and I'll put another stream just hanging out there until we get a verdict, because they still got to get the evidence. They're going to get lunch. So I think we have like 2 hours of verdict watch here, and I'm not going to, I'm going to play with them a little bit to keep them okay instead of sitting here on the computer. But finish what you were saying. I'm sorry.
Her inclusion is a significant development, because obviously they could be going after the veracity of witnesses. What do you remember? What don't you remember? Did you see that shrink? That shrink is known for, putting in false memories, things of that sort. I don't know if they'll have luck or not, but the judge allowing her in as the expert, she's top in the world. I don't know of anybody more. It's kind of like getting Michael Baden as your pathologist.
Oh, that guy's the best. I used to love him on HBO. Let me get through these super chats real quick. The interpretation of immediate knowledge legalizes mob violence with only one person reasonably responsible being the bad actor shouting false accusations. It's possible, but that's why the probable cause is still required. So it's possible. Wouldn't guard A statement be hearsay? Yes. Wouldn't guard B be prudent to inquire on the grounds? Yes, but it's not only it's the reliance is not only on that statement. You also, you can rely on the fact that you're working as a team. His responsibility is that can you reasonably rely on his statement? It's not just somebody saying, "Hey, this guy stole something." It's we're working together. I'm watching the cameras and I see this person on camera. That's a different type. That's a statement that you can rely on. That's why if you listen to the court, they were like, statements that aren't based in fact, or you can't point to certain things that can help you rely on the statement. So something like this, I think you would be able to rely on, and it happens all the time. They allow those statements in. I mean,
isn't hearsay only in court though? I mean, technically, out there in the field, that's just a tip or it's knowledge, but it's only hearsay. I thought in testimony.
Yeah, it's only hearsay, an evidentiary rule.
It isn't but in colloquial sense, in the way the judge was using it today, it was one person tells someone something else. That's the hearsay. Hearsay is I heard from John. That's blah blah blah. So that's the way they were using it, and this is all for the truth. Victim who is bleeding tells you that they were assaulted, points to the assailant. Do you have immediate knowledge? I'm not sure, Stephen. Victim who is bleeding. Yeah, I would say yeah. But again, all these things are very factually based, though, right? Yep. So, thanks for that super chat. So I'm just trying to get through these before we get out of here. Why doesn't your answer to guard A B question result in probable cause or immediate knowledge for the Michaels neighbor point? Because the neighbor, nobody saw him commit a crime.
Yeah.
Nobody saw him commit a crime. And at best, the only crime they saw him commit was a misdemeanor. And based on Georgia law, you can't chase somebody for committing misdemeanors. So in your guard example, let's say guard A sees the person on camera, radios the guard who's at the door, hey, that person's got the thing, but that person runs out the store. You can't chase him because the person's escaping on a misdemeanor. So even here, even if we give you that, you still got the misdemeanor issue. 2,000 likes, cheers. All right, I'll definitely take care of that, motherfuckers. Add to the instruction, NJ, if you are convicted beyond a reasonable doubt that the defendant is guilty of a charge, this is from New Jersey, charged crime, you must find the defendant guilty of that crime. It's an interesting reverse little take, John. Interesting.
Yeah, must
I think
is more
I think
common,
that's very similar.
I think must is fine. It's interesting to note that the may, which it's interesting. I'm not sure what that is.
I'm assuming because the person is innocent until proven guilty, so you may find them guilty, but you must find them innocent because it's true. If they haven't satisfied those elements, it's may versus must. And this is the last one I'm reading. Listen, thanks again for all the super chats, guys, but this is the last one I'm reading so we can get out of here. Why wasn't MC Deeds, I'm excited the McMichaels, seeing Ahmaud Arbery on the property once again that day, at least partially immediate knowledge? Because they have to say that they committed a crime, right? It's the immediate knowledge of a crime. So even them seeing him on the property or somebody seeing him on the property. Yeah, we'll leave you. All right, take care. But that doesn't give them immediate knowledge of a crime, right? So previous knowledge doesn't work. You need immediate knowledge. So yeah, so that's it.
There's one more
listen, guys.
That's pretty funny.
Oh.
That's a good rap.
Yeah, that's definitely a good rap. Hey, listen, guys. Hey, listen. Thank you to my guests. All of their links to the channels on Civil Law, In Time, and Eric. Their links to their channels are in the description. Or actually, Eric's is going to be in the description real soon. Thank you guys for watching. We're going to be doing Verdict Watch, for the next couple of days. So what I'm going to do is I'm going to make another stream and I'll send it out. If you're not subscribe and hit the bell, and you'll probably get the notification. And that stream will go live when the verdicts are back. So we're not going to be sitting here waiting for the verdicts. So soon as we get the judge back, there's a verdict, we're going back and make it happen. So we're not going to be watching.
Oh, somebody just said judge is back. I don't know if that's accurate or not, but someone just said judge is back.
Well, I still have the stream up. Let's see.
Oh, okay.
I still have the stream up, and
I doubt it's with the verdict. It's probably just
the judge is not back.
Okay.
But
he left his lunch. He went to go grab it. No.
So we're going to see what happens again. So we have a lot of people saying guilty. We got a lot of people saying not guilty, but the jury is going to be the last to decide. So if they don't come back today, we will be here tomorrow. Whenever the verdict goes, we are going to go live at that time. So thanks again for my panel guests. Thanks again for all the people who joined us. Thanks again for all the super chats. My name is Nate the Lawyer, and we are